Yeah.
Can it be pulled down? Yes,
Sure.
it's very warm.
Sure, yeah.
Thanks.
It was
Good
at
morning.
maximum. It was at maximum an hour ago.
To me, it feels like it's a little bit warm in the courtroom, and I just asked the court officer to make it a little cooler. So if anyone else is warm the way I am, feel free to take off your jackets. But the panel will continue to wear its robes
Oh, man.
and jackets. I should have thought ahead. Good morning. Welcome to this sitting of the Massachusetts Appeals Court. It is my great honor and privilege to be sitting today with Justices Shin on my right and Justice Ditkoff on my left, and my name is Gabrielle Wolohojian. We have a full list of 6 cases this morning. Unless something goes awry, we will hear the first 3 and then take a morning recess of between 10 and 15 minutes, and then hear the last 3 cases. Each side receives 15 minutes to argue. There is no rebuttal in the appellate courts of Massachusetts, so don't reserve time for rebuttal because we won't give it to you. You may construct your argument in any way you wish. However, I want to assure you that the panel has already read your briefs and what we think are the relevant portions of your record, if not the entire record. And so you don't need to feel that you have to tell us the background of the case because we are familiar with it. That said, you can obviously construct your argument any way you'd like. When the yellow light goes off, you will have 1.5 minutes left to argue. We'll try to refrain, but that's not a promise, from asking you questions during that period so you can wrap up your argument gracefully in the way that you'd like. And with that, I am going to call the first case on the list, which is 2023 P0062, Commonwealth versus Robert EKMALIAN. And Attorney Moore, did I pronounce that correctly?
It's Maurer, but close enough.
Maurer, okay, I apologize. We're ready whenever you are. Just adjust the microphone, but frankly, there's no substitute for good projection.
Thank you. May it please the court, my name is Ann Maurer, and I represent Mr. Robert EKMALIAN. I'd like to start with the second argument in my brief, that the Commonwealth's use of the phrase "pretty clear" to describe the burden of proof lowered that burden, infringing on my client's due process rights and creating a substantial risk of a miscarriage of justice. I think the first question before this court on that topic is whether or not the use of that phrase, in fact, was error. And our position is that it was the way that the prosecutor used that phrase coming at the tail end of the summation, describing it.
The prosecutor used it, the same phrase, sort of 3 or 4 times right in a row, each time referring to facts as opposed to the burden of proof. I didn't see any mention in that portion of the argument to burden of proof. I saw mention of facts. Do you think that makes a difference?
The way that the prosecutor used it in that, in the transcript, it is 1 paragraph, but it comes after a recitation of the facts of the case at the very end of the summation, and what she starts by saying is, all you have to find, and then
But
goes
finding
through.
refers to facts normally. I mean, she may have not been that precise, but findings normally refer to facts.
That's true, but she's listing the 3 elements of OUI in this case. So she says that all you have to find is that the defendant was operating his motor vehicle, and I think that's pretty clear. And then as she's describing each legal element of the crime and what the jury must find, she describes the weight of the evidence as being pretty clear, and making an analogy to, or directing the jury, in fact, that they must find that the evidence was pretty clear. That was the impact of the way that those phrases were put together, whether it was deliberate or not. It instructed the jury that, in fact, they could find a lower burden of proof here in this case.
And why is there a substantial risk that the jury convicted your client on a standard of pretty clear rather than beyond a reasonable doubt?
Well, the biggest reason in this case, when you look at all the factors in determining substantial risk, is the strength of the Commonwealth's case. So this is not a case where the evidence was very strong. There was evidence of driving, but the only evidence of driving, in fact, showed responsiveness and alertness. My client was in a Cumberland Farms with bright lights shining on him when he turned the car on and drove out onto the streets of Ware in the middle of the night where it was dark. Within 100 feet of leaving the Cumberland Farms, he, before seeing the cruiser's lights, realized that his lights were off and turned them on. The officer testified that it was less than 100 feet from leaving the gas station. So he committed a traffic violation, but in correcting it, showed that he was in fact alert and responsive. And then most of the evidence that the Commonwealth relied on to argue that he was in fact impaired comes during the traffic stop in the interaction with my client. And that evidence, frankly, was not strong. The field
Even accepting all of that, that there was a weighing of the evidence and conflicting evidence for the jury to consider, what do we do about the fact that the judge instructed the jury on the proper burden of proof multiple times?
So the judge gave standard and accurate instructions to the jury, but in a case like this where the evidence was so weak and the prosecutor themselves made no effort to correct the improper burden in their summation, that basic instruction was not sufficient. Because this, and it really goes back to—
You have a case where we've, under substantial risk, where the judge gave the instruction on the burden of proof at the beginning of the trial, in the final instructions, and then a third time after the jury asked a question, and we determined that nonetheless the jury would have disregarded that and based on something that the prosecutor said in closing, found that there was a substantial risk of a miscarriage of justice?
I don't have a case exactly with the facts that are similar to this case. However, in the substantial risk cases, where a prosecutor makes an error of law or instructs the jury essentially as to an error of law, there are also usually very strong facts for the Commonwealth. So there is also no case that I have been able to find where there's an error in the summation by the prosecutor and the judge's instructions alone cured it, meaning that that alone would overcome an error where the case was weak as it was in this one. Should I repeat myself or
No,
try to rephrase that?
I'm trying to think through that there's literally no case that we've found where a judge's instruction cures an error in a prosecutor's closing?
Not where the facts for the Commonwealth were as weak as in this case. So ordinarily, it's a sort of a
The judge gives
totality
a
of the
correct
circumstances.
instruction, we assume they follow it.
Yes.
Okay. And you've given us no reason to think they wouldn't have here. So that's where I get a little hung up on your argument, because if we follow the rule that the jurors will, follow the judge's instructions, where does that leave us?
Well, Justice, in this case, I think that we can actually go to the jury's questions during deliberation, and from there we see that they actually were not fully understanding the judge's instructions. When they were going back to the evidence that they were presented with, they had questions about whether the defense agreed with the results of the field sobriety tests, why there wasn't a breathalyzer test. The evidence that they were presented with gave them a lot of pause. And so I don't think this was a jury that fully understood their task, and that the judge's instructions here did not cure the error in the prosecutor's summation.
Do you want to say anything about your first argument?
I'll rest on my brief.
Okay, let me see if there are any questions. No, I think we have it. Thank you very much.
Thank you.
Attorney Lynch?
Good morning. May it please the Court, Bethany Lynch, Assistant District Attorney for the Commonwealth. I will also limit my argument to the closing argument issue. I think that of paramount importance is the contextual reading of this, of the closing argument section that's being challenged, and the language that the prosecutor used is referring, I would suggest, to the strength of the evidence, not to the burden of proof. And at no point did she encourage the jury to apply any lesser burden of proof. In fact, she didn't discuss that, as a prosecutor shouldn't go and try and explain what reasonable doubt is and what the burden of proof is in her closing argument. That is more in the province of the judge. And so I would suggest that that the prosecutor in this case made no error whatsoever in arguing
Well,
in
I'm
her
not
closing.
sure that the prosecutor is supposed to offer an opinion on the evidence, so on the strength of the evidence. So when the prosecutor says, I think that's pretty clear, why is the prosecutor's personal opinion about the strength of the evidence proper matter for closing argument?
I think that in reading this in context, it's clear that she was arguing the
Clear or
strength.
pretty clear?
I'm sorry?
Clear or pretty clear?
I would suggest to the court that they may find that it was pretty clear that she was arguing the strength of the case, which the prosecutor is allowed to do. It may have been inartful to say, I think, but I think that, and I just said it, in the context of the argument that she was making, she was arguing, she had just argued the facts of the case, the evidence and the strength of the Commonwealth's case on the various elements, and this was her wrapping up paragraph, where she did argue to the court, to the jury, that the defendant, the evidence of operation was strong, or pretty clear. It was clear evidence of operation. There was clear evidence that it was a public way upon which he was operating the vehicle, and it was pretty clear the evidence was very strong that he was impaired. And in that, well, I'm not going to go into the evidence at this point, but I would suggest that that is the basis of her argument. There's no indication in her argument that she was urging the jury to apply any lesser burden, or that she took on any lesser burden of herself than what is required for her to prove, which is each element beyond a reasonable doubt. Even if her language was inartful and it did in some way confuse the jury, I would suggest the fact that the trial judge very clearly instructed on the burden of proof, as Justice Wolohojian said, multiple times, both before and after the evidence in the case, also argued that the jury was to take his instructions as the instructions to apply to the case. They didn't have any wiggle room there. They have to apply the law as given to them, and he gave the instructions correctly. As for the jury questions, I would suggest that the questions have to do with facts. They aren't burden questions. They don't seem to be trying to figure out what burden to apply to the facts. This jury in a district court in Belchertown wanted more facts. They had additional questions that they didn't get through the course of the trial, and they just wanted more facts. And they didn't receive them because the judge can't give them any more facts. So they were so instructed and re-instructed on burden of proof. So I would suggest that the judge's instructions, which the jury is presumed to follow, were sufficient to cure any error that there may have been in the closing argument, to which I do not see that there is any error there. Also, just very briefly, I would disagree that the evidence was weak. I would suggest that the evidence in this case was actually fairly strong. Again, there was no question as to operation or in terms of sufficiency and the strength of the evidence. In terms of operation or in terms of public way, it was the entire trial focused on the issue of impairment. And I would suggest, I'm not going to run through all of the facts, but I would suggest that the facts that were before the jury in this case about his performance on the field sobriety tests, about the fact that his eyes were bloodshot and glassy, the fact that he was unable to open a car door, he was leaning, all of these things together, along with the fact, again, there was testimony that the officer, who is a field sobriety test trained officer, trained to perform, have these tests performed for him, he opined that this defendant, he looked for, I believe it was 8 markers in the 9-step turn, walk and turn, and he markers of impairment, he found 6. He was looking for 4 markers of impairment in the one-legged stand, he found 3. And that, with the totality of the circumstances, led him to believe that there was impairment. So I would suggest that the evidence is in fact strong. So that would wrap into whether or not any error in the closing argument created a substantial risk of a miscarriage of justice, and I would suggest very strongly that it did not. If the court has no further questions, I would be happy to rest on my brief or answer any questions you may have.
Thank you. I think we're all set. We
you
understand
very
both of
much.
your arguments. Thank you both, and the case is submitted. I'm going to call the next case, but I've been told I need to pause for a few seconds for our recording system. But the lawyers who are here for the next case on the list should feel free to come up to the tables for counsel. Yeah. Thing isn't lit up. There we go. Okay. So the next case is 2020 P 1195, Commonwealth versus Pedro VAZQUEZ. Attorney Allen, is that correct?
Yes, Your Honor.
All right. Well, we are ready anytime you are. Adjust the microphone, and please don't forget to speak up. Thank you.
Good morning, Your Honors. May it please the Court. Ashley Allen on behalf of the defendant appellant, Mr. Pedro VAZQUEZ. There are 2 issues on this appeal, and so I'd like to get right to the jury issue unless the Court has any other preference. So normally I don't do a brief recitation of the facts. I understand you've paid attention to the case, but I think it's really important in this case to understand what exactly happened between these jurors, and also the Commonwealth, even in their statement of issue, says this occurred after deliberations had ended. But I think it's really clear in the 4-person's note, as well as the 2 jurors' questioning by the judge, that this started in the jury deliberation room. There were statements made in front of the other jurors. So when the juror 2 was questioned by the judge, he made a statement that he said, "I did not assume that this gentleman was a racist based on one statement. There were other statements and incidences within the deliberations." And then he continued, "I came to that conclusion based on a label he gave me during deliberations in front of everybody." And then
I have a quick threshold kind of procedural questions.
Absolutely.
Before you get into the substance. And I may be wrong here. So if we look at the 2 arguments on appeal, you've got your argument that it was an error to not give an involuntary manslaughter instruction. That argument I could see bearing on whether or not the defendant's conviction needs to be reversed, or right? But the first argument, I don't see that. It's more of an argument that might, if it were to succeed and presented in a certain way, permit the defendant to obtain a new trial, correct? It wouldn't operate directly on the conviction.
I don't think that that's what the SJC said in Ralph R. So this court had decided in Ralph R. that the conviction should be vacated.
But there was a whole fiddler process that was engaged in Ralph R., which we don't have here. Did you file a motion for new trial down below?
I did not file a motion for new trial.
Was a fiddler motion filed down below?
There was not.
Okay, so do we have any case where on direct appeal this kind of issue has resulted in a new trial when you haven't filed those predicate motions?
I think since the SJC has determined Ralph R. that this is a direct appeal issue. When I first had asked for a stay in order to investigate whether or not there was a new trial issue, that was in August of 2021. This court decided the first Ralph R. Shortly after that. And then the SJC decided in Quiles at the end of August, so all within this month, that this is a direct appeal issue, and the burden falls on the judge to determine whether or not the jury is impartial.
So is that why no new trial motion was filed?
Correct. Yes. So at first, and obviously that would put the burden on the defendant to then prove that these statements were made, and then he would get a hearing, and we'd have to put the
Where
jury.
I'm having trouble is that the issue is briefed as though this is presumed prejudice, but Ralph R. says very clearly it is not. It's a waivable issue, right? And so there has to be a substantial risk of a miscarriage of justice. And I don't see that briefed.
So Ralph R. did say that when there is my apologies, a guilty verdict arising from racial bias, it is a substantial risk of a miscarriage of justice. So the only thing, when they've waived structural error by not objecting to the judge's inquiry or not doing a further inquiry, now the defendant has a more burdensome standard of prejudice, which is a substantial
But we
risk.
don't
and he's
have
waived the
we don't
structural
have
error.
we don't have a verdict infected by bias, as far as we know.
Well, we have more information in this case than we did in Ralph R., where they
Right,
did
and that
say-
actually, I think, weighs against a finding of substantial risk, because in Ralph R., there was no inquiry, whereas here there was an inquiry.
So
And there was confirmation from all three jurors that they could be fair and impartial regardless of this dispute between the two.
So I'm glad you
jurors.
bring that up, because I think that is insufficient. I mean, there was an inquiry, but the judge kept saying, I don't want to hear about these statements. The judge didn't have enough information at the time to determine one way or the other whether the statements reflected actual bias, and if they didn't reflect actual bias, whether or not the statements still infected the jury enough in order to make it impartial. For those reasons, I mean, it was insufficient for him just to ask them whether or not they can remain impartial.
But
The
it
second
has
reason-
to be some kind of bias that infects the defendants or affects the defendant's rights to a fair and impartial jury, correct?
Right, and we don't have
All
enough
right, so we
information.
don't know the race of the defendant and the race of these jurors. We don't know if
We do
this
know.
is.
We do know
the
that Mr.
race.
VAZQUEZ is Spanish. He's of an ethnic race, and the juror number 2 is a black man, which was said in the transcripts and is cited in my brief. And the racist statements made by juror 4
And juror
against him.
number 4 what is the race of juror number 4?
I don't know what I assume that he is not a black man, given the context
I
in which
know,
these
but these are
statements
the
were made.
kinds of things that, like, we can't really assume. So
So if this
we
was-
need a record, and that's all I'm trying to suggest, is ordinarily that record is developed below.
And I would agree with that if this was a post-verdict affidavit from a juror saying, hey, during deliberations, there was these racist comments made. This was triggered. The
So
judge had known.
how do we get to the leap? Assume that we know, I get 2 and 4 mixed up in terms of numbers, so I can't tell you, but assume we know that one juror is black, and we know that the defendant is Latino, Spanish, I don't know. How are we then, is your argument that racism against or prejudice against a black person will be transferred necessarily to racism against a person of a different ethnicity?
I think that there were stereotypes.
Do we have a case that says that? That you say you just transfer prejudice against a black person as prejudice against a Latino person?
Not as I stand here today do I have a cite for that.
How would we, but aren't you necessarily asking us to make that assumption without a predicate record?
I don't think you need to make that assumption. I think that we have a jury that maybe was impartial. These comments were made in front of other jurors. The foreperson wrote a note that they have concerns about their preconceived biases, which are stereotypes and prejudices against a certain group, and whether or not we don't know.
We don't know which juror the foreperson was referring to.
We don't, and that's the problem, and that's why the judge should have
It
inquired
could have been juror
further.
2, right?
I'm sorry?
It could have been juror 2.
It could have been juror 2.
But can you just, I mean, I'm still having trouble. Can you just walk me through why there's a substantial risk of a miscarriage of justice?
I think it's plain from the SJC's decision in Ralph R. that when there is racial bias infected into a jury, and that it is the judge's determination when he needs to make a further inquiry, and he didn't even do the preliminary inquiry here.
So you're
now
arguing it's basically automatic reversal if a judge doesn't make sufficient inquiry?
I think in this case it is, and this case falls in a very, I mean, I don't think there's going to be many cases that this comes up in, because there hadn't been a case that really described any of the procedures since
But
Tavares,
the difference
which was in the 80s.
the difference with Ralph R., well, there are 2 big ones, I think. First is there was an inquiry in this case, whereas there was no inquiry in Ralph R. Hold on. And here, the defense counsel invited the error. right?
So if I could respond to so the other reasons why, so the first reason why it was insufficient as to the inquiry was because we don't know what the statements were made. And then the second one is, I mean, if you were to ask juror 4, or if any other juror was racist, the concurrence in McCowan recognized that we have unconscious bias, and that's a problem, and that there is an interest in not overtly expressing racism. So he needs to consider all of that information before he can determine if somebody's impartial. If someone's accused of making a racist comment or being a racist, maybe they say to the judge, yeah, admit to it, but there is an interest and the judge needs to make those credibility determinations like Ralph R. said. Those were not found here. There was no credibility determinations. And in Ralph R., they actually said that he didn't find the jury foreperson's statement credible. They said that because she was trying to get out of it because
there's
of work.
an implicit finding here once all 3 jurors have been voir dired, that and they've told the judge that whatever has occurred will not affect their ability to be fair and impartial. I think there's an implicit credibility determination that the judge makes that he believes all 3 of them.
Without knowing what statements were made.
Well, we know what they've said.
But
We
he
know
didn't
right
know
there.
what the statements that were.
He didn't
except
know.
for
He
knowing
didn't
that,
know
and
what
there
had.
was-
That is true. He
and
did
every
not.
single time he said, "Stop! I don't want to know anything about that," and warned them 4 times, I believe. I don't
It's
want to hear about the
careful not to
deliberations.
misstate the record. It's important not to misstate the record.
Correct.
He knew some of what had been said. The only thing he insulated himself from the judge insulated himself from was knowing what had been said within the jury room. He
Which I
knew
think
what
is the
had
biggest
been said,
problem.
excuse me. He knew what had been said once the 2 jurors were outside on the sidewalk, right, and in the stairwell. So I don't think it's accurate to say the judge had no idea what had been said.
So the statement from the foreperson where there were statements made and there are preconceived biases. He does not know what was said in front of the 9 other jurors. He doesn't know what was said to have ignited this, quarrel between these 2 jurors. Juror number 4 said their dispute did have to do with the deliberations. So I think we can make the inference that whatever was said in the deliberation room spilled out onto the streets of the court, outside of the courthouse. But there was more said beforehand. And so while he might have understood a very small portion of what was said, he never checked to see how the other jurors were affected. He never checked to see what the preconceived biases that the foreperson was talking about.
And so in Ralph R., the SJC said, we cannot be certain whether comments reflecting racial, ethnic, or other proper biases were made. But what your friend says in this case is, let's be certain. Let's bring the jurors in and do the inquiry that should have been done and find out especially in a situation we don't have to worry about affecting the verdict anymore. So why won't that get us? Who knows where that will lead us, but why don't we do that?
Well, because in Ralph R., they also say there's 2 very distinct procedures, and those depend on when was this raised. Was it raised during the trial, pre-verdict, when the judge had an opportunity and could make these credibility determinations? It falls on his shoulders. And so I agree. The defense counsel did not strenuously object to this. He was in agreement.
He did not object at all.
He was against.
He did not object at all.
He was against it.
So I do want to talk about that, if I could get to that just after answering your question. And then the second avenue is this post-verdict. And so does the burden fall on the defendant? We're taking a pre-verdict case, and we're now putting the burden on the defendant to interview these jurors, which is burdensome.
Well, no, we don't have to do it that way. We could say in a motion like this, the judge should bring in the jurors and interview them himself. Himself?
I think that would be a creative way of doing it, but I think it wouldn't be in line with precedent, which is Ralph R. saying, the SJC saying in Ralph R. that there's pre-verdict and post-verdict, and they don't make any qualifying factors of, well, if this happens pre-verdict and the defendant doesn't object. In Ralph R., they didn't object either. They also had to meet the substantial risk thing. Standard. But the Commonwealth also says when we get to the invited error portion, they said the Commonwealth repeatedly requested the judge make further inquiry. The defendant repeatedly opposed it, and the judge did exactly as requested. That's not true. I mean, they strongly opposed dismissing any juror, And they agreed with the judge not to make further inquiry, but the Commonwealth, I mean, I searched the transcript 4 times over just last night trying to find where the Commonwealth was referring to. They also agreed with voir direing every single juror on whether or not
I
they were
think the
impartial.
Commonwealth wanted the judge to ask the foreperson about the note, and defense counsel objected to that.
They agreed with what the judge had said he was going to do, that he was
I mean-
disinclined to do it, and that was the same in
But
Ralph R.
he
as well.
offered a reason, too. He said, well, preconceived biases could just mean personal experience.
Right, and the same thing happened in Ralph R. And they said, well, we don't know one way or the other what they meant because the judge didn't inquire. So, well, I mean, in every material
There was
respect-
enough inquiry here that we know it was a juror dispute. A dispute between 2 jurors, right? In Ralph R., the judge had no idea what was meant by discriminatory comments, right?
I don't think so. I mean, the judge in that case also thought, that could mean a number of things. And in Ralph R., the SJC said, that's the problem. We don't know what they meant, and so the judge needed to go further and inquire. So same thing in this case. The judge couldn't make the determination because he didn't have enough information.
All right, so let's assume you're correct. I'd like to go back to Judge Shin's question, which, given that the error is it's not a failure to inquire in its totality, it's a failure to inquire further.
Correct.
Where's the substantial risk of a miscarriage of justice? Because that error was not preserved.
It's the possibility that the jury was infected with racial bias and couldn't remain impartial. And so I understand that the judge inquired about the impartiality, but I think for, the fact that they didn't inquire of all 9 jurors, there are, unconscious biases that people aren't going to overtly express their racism, and that he didn't have enough information, that is a substantial risk of a miscarriage of justice. And I see that I'm out of time. If there's
Yeah, so
further
let me
questions-
just see if there are any further questions. Do you have any further questions? Do you have any further? I have one question. I'm going to ask the same question to your brother counsel, but I wondered, given that there were 2 firearm convictions as well, whether guardado might be an issue in this case. If either of you thinks that it might be, please submit some kind of supplemental memorandum with us within a week of no more than 5 pages from each of you.
Could you repeat the first part of what you said? I could not hear you.
Yeah, there are 2 firearm convictions here as well. And I'm wondering whether either of you thinks there might be a guardado issue that we need to be aware of. And if you do, please submit a supplemental filing of no more than 5 pages each within a week of today. Okay? Oh, and we also need the video. If either one of you has the video, would you please file that as soon as you can with us? We need to see it. Thank you very much.
I appreciate your time,
Okay,
Your
thank
Honors.
you.
Thank you.
All right, Attorney Shepard Brick.
Thank you. May it please the Court, David Shepard Brick on behalf of the Commonwealth. I think that the issue in this case is that the judge made an inquiry. He might not have made a completely sufficient inquiry, but I think he knew enough. And to the extent he didn't, that's on the defendant. The defendant objected when the prosecutor said, you got to ask her what she means by preconceived biases. And the judge says, I don't want to do that. And defense counsel said, that could be a lot of things. I don't want you to ask her either. It's an invited error. So
Even then, we would still review it for substantial risk,
Right.
correct? And it's, at least to me, a bit concerning to have facts such as these present, where 2 jurors get into an altercation that they can't get into under control, to the point that it continues outside the jury room. So I think it's beyond a disagreement. The issue of race and bias is at least suggested.
right.
and, you know, there's name calling,
Yes.
not good.
No.
And the judge did not inquire, I mean, I think the Commonwealth agrees that the judge did not inquire as fully as he should have.
Correct.
So why isn't there, on those facts, a substantial risk of a miscarriage of justice?
I think there's not a substantial risk because of a number of factors. I think one, there is evidence in the record that the preconceived biases that the foreperson might have been referring to was juror number 2, which was the one who was accusing juror number 4 of being racist. And the evidence of that is the prosecutor brought to the judge the fact that juror number 2 had a history with the DA's office that was negative. He appears to have held a grudge, and that juror has a history of, in this trial, he had a disagreement with a supposed misunderstanding where he attempts to get another juror kicked off the jury, essentially, before they're sworn.
How does that help? How does any of that help? It feels like the juror, I don't know, it feels as though the judge could have found, if he had inquired further, that the juror harbored biases.
Right.
It doesn't matter if they're against I mean, we don't know. We could make an assumption that they were biases against the prosecutors, right, the prosecution, but
Right.
I don't know, absent a finding, how can we assume that one way or the other?
Well, and I think that's the problem, is absent of finding. This should have been a motion for a new trial. We should have done the Fiddler protocol, and we should have found out. Because, I mean, if there was racism in that room, then we have to do it over again.
Is it Commonwealth's position that if we determined on this record that it did not merit, I don't think it's a new trial. I don't know if it's a new trial, right, or if it's reversing the conviction or what it is, because it's a direct appeal. And normally in a direct appeal, the only things we can do is affirm, remand, or reverse. So, but let's assume we determined that in this appeal, it did not merit changing the verdict.
Right.
Is the Commonwealth's position that that would be binding in any way on a subsequent, let's say, Fiddler motion
No.
or
So
motion for new trial?
I think that the court could affirm the conviction and the defendant could be granted leave to file a motion for new trial where this issue would not be considered waived in any way.
Okay, so the defendant doesn't have to get leave to file a motion for new trial, could just file a motion
Right.
for new trial and raise it in that context. And you would agree this would not be preclusive on that consideration of that motion?
Counsel, your friend suggests, and not without reason, that my idea of the judge calling in the jurors and starting asking them isn't really what the case law supports, that the defense counsel would have to go and try to contact them, and they might tell defense investigator to go pound sand, and we get nowhere. Is she right?
So they're in the Fiddler line of cases. It's escaping me whether it's in the Laguerre case or in one of the follow-up cases, but the court does actually, the SJC actually does say, the judge could have, the parties brought in the jurors, they didn't put on all of the jurors, and the court said, well, if the judge was concerned about that, he could have brought in all the jurors and asked them himself. So I think that there is support for that if the judge wanted to do it. But generally, I mean, the only cases that I was able to find were the defendant files a motion for new trial based on an affidavit, and then the defendant brings in the jurors, potentially the Commonwealth brings in jurors. Certainly, I would want to bring in the foreperson. I think she had a good handle on what was going on in that room. I don't know that you need to bring in everyone. I mean, the judge did ask all of these three jurors if they could continue to be fair and impartial, and if what was said would not impact them, which I think gets us over the substantial risk problem, because you don't have that in Ralph R.
So in this appeal, what's the analysis that we employ for assessing whether there is a substantial risk? Is it the traditional test, notwithstanding what Ralph R. says? So we look at whether it was potentially a tactical decision by defense counsel, the strength of the Commonwealth's evidence. Is that what we look to, the nature of the error?
Well, that's what the SJC said in Ralph R., that it's substantial
Well,
risk.
they said substantial risk, but then what follows was not exactly what we think of as substantial risk, right?
Yes, which I understand that's the precedent. Doesn't really make sense to me in that instance, because it's either substantial risk or it's not. But I think you follow the substantial risk, the general protocol, and to the extent that Ralph R. informs it, in this case, you have the judge making an inquiry of these three jurors that says, it's not going to impact me, I can be fair and impartial, which you don't have in Ralph R., and I think that's what takes this out of that. Happy to answer any other questions.
You have the video? You suggested in your brief you had it?
Yes, I can provide a copy of the video.
Probably be easiest if you produce it, I would think.
Yeah, no, that's not a problem. I can have a copy sent to the court.
Anything
I don't know
else?
if you guys can take it electronically, but I'll figure that out with the clerk's office.
No, we don't have any further questions for you if
Okay.
that's,
Well, I'm
I
happy
think
to
we
rest.
understand your argument. It's a very interesting case. Thank you both. We've been aided by your arguments on both sides, and we appreciate that. We'd also appreciate any supplemental filing if you think one is in order. I'm not requiring it because I may be misunderstanding something here, or I don't know. But with that, the case is submitted.
Thank you.
Thank you. Do we have everyone here for case number 3? We do? Okay, thank you. The next case is case number 2022P1073, and it's Commonwealth versus Jesus Ayala. I don't know if I pronounced that correctly. The first two cases were a little bit short, so I think we're going to take the fourth case for those of you who are waiting before the mid-morning break. So there'll be one more case after this one that we'll hear before our break. All right. Attorney Malari,
Good morning.
we're ready whenever you are. Please remember just to speak up.
Good morning. May it please the court, Edward Malloy for Mr. Ayala. There are two main issues briefed in Mr. Ayala's case, and before I reach that, Mr. Ayala has filed two motions, one to vacate and remand and one to stay the proceedings. Mr. Ayala is indifferent as to which of the two avenues the court would adopt, but the point is that this case was presented along with Escobar, which raised this, in some respects, the same issues in the trial court and also in this court. That case has been vacated without prejudice and remanded for further discovery regarding some revelations from the Office of the Inspector General with regard to the investigation into the Hinton drug lab. I can proceed to the...
But why wouldn't we just rule on this appeal? Obviously, if you win, we won't have to deal with all that IG stuff, and if you lose, you'll get another shot at it with the IG stuff. I don't see what the point is in stopping at this point.
Well, the revelations from the Office of the Inspector General may provide a separate basis for a Rule 30 motion, but it may also simply provide support for the court's exercise of discretion to grant Mr. Ayala's original motion for new trial where the court didn't choose to exercise discretion in that direction to begin with. Also, there is a large degree to which the arguments about the invocation of generalized concerns for the integrity of criminal justice system are similar between Mr. Escobar and Mr. Ayala. Mr. Ayala's case is obviously not the same as Mr. Escobar's, but those were briefed by Mr. Escobar, and Mr. Ayala was joined in those arguments before this court. So,
Did Escobar involve a plea that was taken after the discovery of problems at the Hinton Drug Lab and where the defendant agreed to waive any further issues concerning that with respect to his charges?
I can't speak to the specifics of the procedural history in Escobar, but I don't believe that it involved the same waiver issues as are addressed in this case.
Okay, so let's assume that we're going to reach the merits of this case. My first question for you, and again, this might be just a clarification of the facts for me. You've got two, I'm going to go all the way back to, I think it's 2005 and 2006 convictions, right?
Correct.
And one of those involved testing by at the Hinton Drug Lab, but the other did not.
Correct.
Can you tell me with respect to the conviction by plea, by way of plea, for the, I think it's the 2005 indictment that was not the Hinton did not involve the Hinton Drug Lab?
I think that's right, but one of them did, and one of them didn't.
So let's just call it 2005 for these purposes. So how does anything you raise implicate the plea to the charges stemming from that indictment?
There's two answers to that. One is that they were both resolved by the same plea colloquy on the same day. So to the extent that there were strategic decisions made with regard to those cases, they were made together and they were presented to the court together. So if counsel, for example, thought that there was no basis to challenge one of the cases, they may have been indifferent as to what happened to the other one because they didn't understand the implications of the two convictions at the same time.
But we don't have anything in the record that says that.
Well, that's true. The second answer to that question is that the ultimate remedy that Mr. Ayala seeks is to make these convictions not in and of themselves establish all the predicates necessary for habitual offender predicate. So even if it only relates to one of the convictions, that still serves its purpose. The problem in this case was that the pleas to both of those cases resulted in both of the habitual offender predicates being satisfied. If only one of them had been satisfied, then Mr. Ayala wouldn't have suffered the prejudice that he experienced in Plymouth.
Is it your view that you can attack the new plea if you win here?
I'm sorry?
Is it your view you can attack the new plea if you win here?
The new plea, the one in 2014?
No, the one that's happened since, that,
The one in Plymouth?
where he was charged with, the Plymouth one, where he was charged with habitual offender.
That's obviously a separate question. If Mr. Ayala were to vacate one of these two convictions, or more to the point, receive a sentence on one of these two convictions that's less than 3 years, then he could potentially go back to the court in Plymouth. I think it's a difficult argument to make, but I don't take a position on that for purposes of the case, for our presentation today.
I have a hard time understanding a portion of your brief. As I read it, you're saying that you're not seeking to challenge, you do say you're not seeking to challenge the validity of the plea.
Right.
The 2014 plea. You're just seeking to amend the remedy.
Right.
I don't understand that. Have we ever done anything like that? How does that work mechanically or procedurally? We affirm, we don't allow the defendant to vacate his plea. We
Right.
do what?
So a couple of things on that. I submit, I believe, that Rule 30 would permit the court to address the sentence without addressing the guilty finding or the guilty plea, but Rule 30 does, I believe, require a motion styled the way that Mr. Ayala's is, which is a motion for new trial. So getting past that, Mr. Ayala filed the motion arguing that he should be allowed to withdraw his plea, but what he really was trying to accomplish was to accept the remedy that the Commonwealth was offering, which hadn't been negotiated before the Commonwealth filed its response. When the Commonwealth responded by saying that their intention was to null pros the case, that wasn't what Mr. Ayala was trying to accomplish by starting all of this.
I don't understand. The motion says, vacate his conviction in the above matters and dismiss the respective counts with prejudice.
I'm sorry, referring to what?
The motion that you filed in the Superior Court in 2021.
Yes, well,
It doesn't say reduce the sentence. It says
Dismissing-
dismiss with prejudice and vacate.
dismissing with prejudice was the, that was the standard that the Commonwealth, that the District Attorney's Office was putting forward as their global remedy for List 3 cases. But if the trial court would permit Mr. Ayala to withdraw his plea or amend the sentence, whichever term we were to use, he would be satisfied with the
But
sentence.
when did you tell Judge Raschuti that you would be happy just to have the sentence changed?
We never got to that point. The Commonwealth filed their response and the court ruled on the papers. And just with regard tangentially to that, I just want to say that the error of the trial court fundamentally in this case is the refusal to exercise discretion. At the end of the day, Mr. Ayala's position is that the trial court could have denied his Rule 30 motion if it made a finding that the interest of justice would not be served, but both with regard to the Hinton lab issue and with regard to the habitual offender issue, the trial court decided that there were complete prohibitions, complete legal bars to Mr. Ayala raising the issue, and therefore it would not exercise its discretion.
But the judge also found that didn't credit the defendant's affidavit. And that's something that we're bound by
well, he didn't credit the defendant's affidavit
as to what he would or would not have done.
as right. And I submit that in reading Mr. Ayala's affidavit, it's clear on its face that it presents a reasonable strategic decision that is consistent with the record, and it would be an abuse of discretion to find that Mr. Ayala was not presenting what the court has required, which is a reasonable strategic plan for proceeding other than offering.
So the judge did exercise his discretion. You're just saying it was abused.
No, the only abuse of, the court did not exercise its discretion with regard to whether justice had been done, whether it should grant Rule 30 motion.
Well, why isn't that implicit in what he went on to find?
I guess I see that as an alternative ground.
Right.
But the
He's
first,
saying even if the lack of warnings issue is not foreclosed by the language of the statute, I find it wouldn't have affected his decision to plead guilty. Why isn't that an exercise of discretion? And same with the Hinton Lab issue, where he says, even if I were to go forward and consider the interest, I wouldn't find that they warrant vacating the pleas.
if the whole thing boiled down to whether Mr. Ayala's affidavit presented a reasonable strategy, then I would submit that it's clear on its face that it did, and it's an abuse of discretion to find otherwise. But the decision as it was written, as I understood it pretty clearly, started by saying there's a legal bar to Mr. Ayala even getting to that point, and that legal bar is the waiver.
So let's explore this affidavit. He says at the time of the plea in November 2014, if he realized he'd be eligible for habitual offender, he would have requested a shorter sentence. I'm sure that's true. I'm sure he requested a shorter sentence at the time. Or simply finish serving the last year of my original 8-year sentence. And I don't understand that. His plea was vacated. How do you just serve another year of a sentence with a vacated plea?
Right, so I in looking at that after, I realized that is an unhelpful shorthand. But what he's saying is that he would have held out for the same sentence that he got, which was time served, as long as one of the two cases was less than a 3-year sentence. As far as the alternative is concerned, the alternative would be to walk away from the bargaining table and just accept what had already been negotiated. But there's no reason to think that that wouldn't have been a fruitful negotiation because he wasn't asking to do.
But at the time, this being before Bridgman 1, if he walks away and lets the Commonwealth retry, wasn't he at that time liable to get a higher sentence?
Well, Bridgman 1 was decided.
In 2015,
Right.
after this plea.
That's right. It was about 5 months after he entered this plea. So if Bridgman 1 had been decided before that, he would have said, I would have just tried the case. But the unhelpful shorthand here, when he says I would have finished serving the sentence, is that he would have walked away. He would have held out for a sentence that was the same amount of time that he'd already done. And if, for whatever reason, he couldn't have gotten that, then he would have just walked away from the negotiations.
And if the judge did not credit that?
The judge didn't credit that Mr. Ayala.
Because the
I don't
one
want to
thing is,
mischaracterize.
I don't want to say anything, but I mean, I am going to say something, but I didn't see really any kind of record that would establish that walking away would have made sense for the defendant. We don't know about the facts of the underlying cases, the strength of the Commonwealth's evidence. Again, they're two different pleas. They're two different sets of charges. You don't distinguish between the two. We don't know anything about, how sensible or unsensible it would have been for the defendant to walk away at that time.
So for purposes of his last motion, I accept that the facts were not susceptible to a strong defense. Mr. Ayala isn't trying to say that he wouldn't plead guilty. He's prepared to accept the guilty finding. All he's trying to do is accept the sentence or the remedy that the Commonwealth was holding out.
So for that, I just go back to, do you have a case that sort of permits that as a remedial measure in this kind of posture?
I looked, and I don't see a case that says that Rule 30 allows the court to go straight to the sentence, but I didn't see a case holding otherwise, and I believe that Rule 30 is a mechanism to address the just outcome of the case, and that if the court were to get to that point, we could ask the court to change the remedy without vacating the plea, because that's not ultimately what Mr. Ayala
Or we could
wants
just
to do.
allow the defendant to file a motion seeking that relief, which he didn't do before.
Yes.
So, okay, I think we understand. Let me see if there are any further questions. Okay,
Thank you.
all right, I think with that, thank you very much. Attorney Slyman?
Good morning, and may it please the Court, Mackenzie Slyman on behalf of the Commonwealth. I recognize where the Commonwealth has submitted a memorandum in lieu of a brief that my role here is to answer any questions the Court may have at this point.
Well, I have a question or two. This standard memo that was filed here, how often does it work in Superior Court?
I'm sorry, how does it work?
How often does it work? How often do you file this in Superior Court? I know District Court is District Court, BMC is BMC, but how often does this get filed in District Court and the judge says, all right, if the Commonwealth says okay, then I'm going to vacate the plea?
I don't know that I have an answer for you, Your Honor. I mean, I myself have never come across a situation other than the Hinton.
Do you know if it ever works?
I don't know, Your Honor. I know that the Commonwealth, will file null process when they deem it appropriate, but in terms of a post-conviction motion for new trial situation where the Commonwealth assents, I'm not sure that's to a motion for new trial. I myself haven't come across that before.
I'll tell you what concerns me, that defendant comes in and he files a motion to vacate the plea, lulled by knowing the Commonwealth is going to file 8 pages of basically how great we are for agreeing to this with no explanation why it should be allowed, thinking they don't have to make a showing. And, your friend didn't make a showing, but that's because of what he knew was going to come next. It's one thing to suggest you're being friendly to the defendant, but I wonder how many defendants are being lulled into not making the showing they need to make to get these pleas vacated because of the Commonwealth's refusal to sort of engage on the issue. I know you don't have an answer to that, but I think that's something that people ought to be thinking about.
Certainly, Your Honor. I
Both in the
appreciate that
Commonwealth
point.
and the defense bar.
Certainly, Your Honor.
Can I ask a question? Can you give us any help on what I now understand the defendant's relief, what he's asking for relief, which is we would affirm the denial of a request for a new trial, but I suppose he's asking that we would remand for the judge to have some kind of rehearing on the sentencing. Can you give us any help on, can that be done in that way? Do you have any authority for that? Where would we be, how would that work out?
I don't have any authority for that, Your Honor. I don't think that would be procedurally the correct way to address this, where, again, the question, as I understand it before this court, is the exercise of discretion by Judge Ricciuti. My review of the defendant's motion for new trial was not requesting the change of the remedy that he now seeks, so I don't know that a remand would be appropriate. I think the defendant could file a further motion in front of the Superior Court asking for the relief he now seeks, resentencing, no longer challenging the validity of the plea. But I don't think that it, frankly, makes sense to use this motion and how it's progressed from there as the vehicle to do so. I think the defendant could still file a new motion requesting the same relief that he requests
Well,
now.
couldn't he move, try to show that his counsel was ineffective in not seeking this structure that would have avoided habitual offender in the future? Obviously, you'd have to talk to the defense counsel, but
Sure, he certainly could. I mean, I think that the universe...
you wouldn't say that's foreclosed by the motions already raised?
No, I think the motion for new trial, we're confined to the universe of this motion for new trial, the issues that were raised by the defendant, the relief sought by the defendant in this motion for new trial, and are at the position now of having to review, Judge Ricciuti's decision on the issues presented to him, the facts presented to him, the affidavits presented to him, whether what he did with that information was appropriate. But I don't think it forecloses raising that for a second time.
Okay,
very
I
much.
see we have no further questions, so the case will be submitted there. Thank you both for your argument and for your answering of our questions.
Thank you.
The case is submitted. Counsel for the next case should feel free to come up. I'm going to pause a second before I call that case. Wait for the recording system. This is SOEP painting, I'm not sure, Corporation versus GRAYCOR Construction Company, case number 2022P1173. And is it Attorney Lysiak? Okay, I hope I pronounced everybody's name correctly. We're ready whenever you are.
Your Honor, and may it please the Court, my name is Matthew Lisiak, and I represent the appellant in this matter, GRAYCOR Construction Company, Incorporated. Just as a way of very brief background, this matter relates to a construction project at the Boston Garden, a ArcLight theater that was being constructed by the Pacific Theaters Corporation. GRAYCOR Construction Company was acting as the general contractor. It had numerous subcontracts with individual entities within Massachusetts to do work at that project, SOEP being one of them. At this point in the litigation, there is 5 payment applications that were submitted by SOEP between December and December and the end of March of 2020. SOEP alleges that these payment applications were not paid by GRAYCOR, and GRAYCOR admits that they weren't paid. At this point in the appeal, GRAYCOR is not making any argument regarding the Prompt Pay Act. The Prompt Pay Act is pretty standard in terms of how many days the contractor has to pay a requisition that is submitted on it, and the record indicates at this point that GRAYCOR did not pay those requisitions. That was the finding of Judge Wilson in the Superior Court level. It's also the finding in this court's appellate decision in Tachi, basically, which is a standard review of the Prompt Pay Act. It's the application, it's the plain language of the application to the facts in both of those cases. The issue here for GRAYCOR is that the lower court decision didn't review, in our estimation, an important factor in the case, and it's different than Tachi in that at the point in which the payment applications were being vetted by the owner, the COVID-19 pandemic had started.
Right, so you think, as I understand it, you think that you might have an impossibility defense.
That's
and
correct.
that in some ways summary judgment was entered against you prematurely because it didn't take into account your impossibility defense. Is that correct?
That's correct, and it appeared...
All right, so when did you first assert impossibility down below? I'm going to ask you for record citations because I couldn't really find it.
Sure, so the impossibility defense was never part of any payment application or anything like that. This was submitted at the summary judgment level. So it was
only on summary judgment that you first raised it?
That's correct.
Okay, so where in the summary judgment did you raise it? It wasn't raised in your answer, I don't think, actually, to the complaint.
No, it's not.
Okay, so, and is impossibility an affirmative defense?
It was not included as an affirmative defense.
But is it an affirmative defense ordinarily?
Yes, it is an affirmative
Okay, so it wasn't raised in the answer.
Correct, Your Honor.
Okay, and then you try to raise it, or you do raise it in opposition. I forget if they were, who first moved for summary judgment here, the plaintiff or the defendant?
SOEP, the plaintiff.
SOEP, okay, the plaintiff. So you raised it for the first time, impossibility for the first time in opposition to summary judgment.
That's correct.
Okay, so now let's look at the Rule 9A statement
Yes.
and see what facts there raised a triable issue of fact about impossibility. You'll just tell me specifically which ones.
The facts specific to the impossibility defense are related to...
So just tell me which page you're on so I can find it too, please.
I'm sorry, Your Honor, you said...
Just tell me which page you're on so I can find the facts supporting the impossibility defense.
Of our brief?
Of the 9A statement. You know, summary judgment, you're not entitled to defeat summary judgment just by saying, we have an impossibility defense. There would need to be some sort of factual basis for thinking that defense could go to trial. So
Sure,
I'm
Your Honor.
looking for those. I didn't see anything, and maybe we can, shorten this up in some ways or make this more efficient. I didn't see anything that said we couldn't pay, we GRAYCOR couldn't pay, we were prevented from paying.
That's correct, Your Honor.
Okay, so if you don't have that, but we see that someone else might not be able to pay from whom you were expecting contribution, then how did you sufficiently raise impossibility as a defense to defeat summary judgment?
Well, Your Honor, obviously, it wasn't, we don't believe it was analyzed. So the facts that we presented at the summary judgment hearing that were in our summary judgment papers, which are not included in the appendix.
Which is another reason why you might lose.
So I understand, Your Honor, but there are documents that are included in our record appendix that show some of the difficulties that GRAYCOR was facing pursuant to Pacific in terms of getting their payment applications and the work that was done by SOEP approved. So that's the real issue, Your Honor. So in the way that this construction project worked is that SOEP would submit change orders through GRAYCOR. GRAYCOR would nominally approve of them and send them off to Pacific to actually review and determine if the work was done correctly. We determined, and it's in the record, and it's in, it is in both the, in Stephen Whitman's, who was the project manager's testimony, that there was about $150,000 to $160,000.
What page are you on?
Sure. So the actual
Of the appendix.
It's pages 107.
What I see here is a reference to compliance holds.
Yes, Your Honor. Well, that was part of our initial argument, but we
Okay,
forgo
but that
for-
doesn't have anything to do with the pandemic, as far as I could tell.
So that does not. So we.
That was a separate argument that's no longer pressed on appeal.
That's correct, Your Honor.
So on appeal, it's, looking at the record that we have, is there anything in the record to support your argument that it was impossible for GRAYCOR to pay on time, according to the Prompt Payment Act, because of the pandemic, which is the argument that you're making? Was there record evidence? Because I'm going to ask you to give it to me.
Sure. Yeah, so, Your Honor, if you could direct your attention to Rep. Appendix 104.
Okay,
Steve
let's look
Whitman.
at 104.
Yes.
Where exactly?
This is the Stephen Whitman's deposition testimony where he's
Okay, which page of the deposition testimony?
that is 209.
209, okay. I don't see anything on there about the pandemic, do you? Or impossibility?
So, well, Stephen Whitman is not going to be bringing up an impossibility to defense.
Okay, so I'm just trying to
Sure.
find out what in the record supported the argument that you were entitled to take an impossibility defense to the jury. Because what I'm trying to get at is, let's assume we agreed with you that the Prompt Payment Act isn't intended to foreclose a defendant from raising all possible defenses to payment. I don't know that we need to reach that here, because I don't know that you had enough facts to suggest that you have an impossibility defense that merits going to a jury. So I don't see those facts in the record.
So, Your Honor, so I would point to his deposition testimony that talks about the amount of money that was submitted to Pacific, who did not approve them, and then essentially went belly up, furloughed all its employees, and stopped working. That amount of work, which a good portion of it was SOAP's work, and it was requested by the owner, had to be actually approved of by the owner. There's nothing GRAYCOR could have done.
Can I ask you this?
Yes.
What was the basis of the summary judgment motion? What was argued in the summary judgment motion? Was it just the statute?
It was, Your Honor. It was based on a strict reading of the statute. We did not pay
So there
after 45
is
days.
no second argument made that that SOAP is entitled to judgment as a matter of law on the merits of the contract
They're
claim?
entitled as a matter of an application of the Prompt Pay Act. And that the amounts are deemed approved, thus summary judgment is warranted at the trial level.
Okay, and then you came back and you argued that it's because you have an impossibility defense.
Well, there were several arguments, obviously, Your Honor, but at this point in the stage,
Then were there any further proceedings on the merits of a potential impossibility defense?
No, Your Honor.
Is there any argument on that?
Other than the oral argument at the summary judgment hearing.
Well, I'm looking at their reply for summary judgment, and on page 5 it says, Grayer's failure to pay SOEP is not excused by the doctrine of impossibility. And then it goes on for pages explaining why impossibility wasn't available here.
What page is that?
This is in the...
Oh, okay, I'm just missing a bunch of things.
I'm sorry, in what are you
It's on your appendix. You didn't put in your friend's reply to summary judgment, but you're telling me he made no argument about impossibility, and I'm looking at it right now.
So that was a reply to our inclusion of that defense within our opposition. I thought you meant from Judge Wolohojian's question. Justice Shin's question. I thought that meant the actual summary judgment motion. That initial one was strictly about the Prompt Pay Act.
Okay, I understand now.
All right, I think we get the thrust of your argument. Let me see if there are any further questions. No. Is there anything further you'd like to say?
Yes, so Your Honor, I would just like to point out at this point, Massachusetts courts have not, there has not been a lot of COVID-related impossibility case law that's been developed. The Lafort cases, Lafort Enterprises is the one that's most recent. It's probably the one that's most applicable to this case. I'd just like to point out that in that case, the Supreme Judicial Court stated that we shouldn't be precluded from hearing and determining the applicability of impossibility defenses in contract cases. That because of the extent of COVID-19, its effect on our society.
Sure, but you just had to raise it within 45 days of the request for payment instead of approving it.
Well, GRAYCOR would disagree with that, Your Honor, but the fact is that the people that are making these decisions are construction workers. They're not attorneys. They're not making these.
You may have a claim against them, it seems like to me, but I'm not sure. We'll have to look further into it, but we understand your argument.
Okay, and I will rest on my papers.
Thank you. Is it Attorney Briansky?
That's correct, Your Honor. May it please the Court, Richard Briansky on behalf of SOEP Painting Corporation. And let me just briefly address the impossibility defense, because I think at least what I understood you to say is that there was no basis in the record to even raise it. But separate and apart from that, there are two legal justifications or two legal remedies that were available to GRAYCOR, which the court could take judicial notice. One is 254, which is the mechanics lien statute, which independently provides a right against the property owner, which, if it was exercised properly in this case, would have provided an appropriate remedy in the event that the owner, the lessee, was unable to pay. Likewise, the Prompt Pay Act takes into consideration this sort of risk, and although it excludes the pay if paid defense, it does allow the filing of a notice of contract before the first application is filed to protect a general contractor in this particular circumstance where the, quote, owner goes into bankruptcy. Then the pay if paid defense, assuming you complied with the other conditions of 14929E, would allow the establishment of a pay if paid defense. Both of these legal remedies were available.
Can you spell out for me how that works timing-wise? Because what's hard for me to understand in terms of the way Tachi talks about the Prompt Pay Act, which makes it sound completely absolute, and so that even if a defense to payment, a legitimate defense to payment, arises after the time for disputing the charge, Tachi could almost be read to be saying that doesn't matter. Can you help me with that? Because what I'm struggling with is, let's say, sub submits bill based on what the general knows at that moment. The general approves the bill within the time, passes it along to the owner. Time comes for paying because there's no dispute, or the general has not disputed it timely. The Prompt Pay Act would make it look like you have to pay the sub at that point. It was not known or knowable, let's say, up until that point, that the sub was committing fraud. This is a hypothetical. I'm not suggesting that's the case here. What happens in that case? Is there no relief?
No, what Tachi would suggest is that there are two separate and independent inquiries. The first is, and which was separated out, and it was the reason, and in Tachi there was a counterclaim, and the counterclaim was asserted by the owner, basically saying we have all of these defenses, and these are legitimate, similar to this, these are legitimate defenses to payment, and they may offset in the totality the amount being sought. But what the court did, which I think is the correct interpretation of the Prompt Pay Act, which is to give its legislative intent, is separately analyze the individual pay applications and then enter separate and final judgment on those particular applications for payment. I think there were 7 in Tachi.
So when do the defenses get raised or tried?
They were tried in a separate action. The court said you can still raise them,
okay,
and you preserve them, and ultimately they may be set off. But we're going to effectuate the intent, and basically,
so
and I know
here, what would be the relief for the impossibility? We would, is that still going to be tried down below? I mean, the case down below is still open, right? Because it was only a partial summary judgment entered.
Well, one of the significant facts here, which was glossed over by GRAYCOR, but I think is super significant, is that these applications were not disputed. They were approved.
I know.
And that has some significance under the Prompt Pay Act, because it says shall pay. And it shall pay within the time set forth in the statute.
But then let's just assume that there's a later discovered legitimate defense. In this case, the pandemic created impossibility. Just assume it hypothetically. All right, just assume that, right after they approved those bills, the pandemic came and made it impossible for them to pay. Just assume that. I'm not suggesting that's what this record shows, but assume that. Procedurally, how would that then all play itself out in the litigation?
What Tachi would suggest, and what the prompt was consistent to reconcile both positions, would be a separate counterclaim for the amount of damages.
It's not a counterclaim.
It's an affirmative defense.
In this case, I think that would be a problem, because that could not be
I'm
Why
just
can't-
trying to ask you not about this case. We understand you're not agreeing to any of this. I'm just trying to
No.
understand in the abstract. You're saying that it could still, the impossibility defense could still be raised.
I don't think the impossibility defense could be raised because it would either have to be disclosed at the time of the application for payment or be foreclosed.
That's not what Tashi says. It says you can file a motion for recoupment. I don't understand why, question whether they can amend their answer this late. But in a case where it isn't like that, I don't know why you can't file a counterclaim for recoupment based on you paid contractual amounts that you shouldn't have had to pay. Unjust enrichment.
That's basically what I was suggesting. There has to be some sort of affirmative claim asserted. It can't just be an affirmative defense in order for it to work.
Okay,
Tachi,
so
there
if they
was a
had,
counterclaim asserted.
if they had raised it in some kind of appropriate way, you would agree that that would be open to litigation within your complaint based on the Prompt Pay Act?
Absolutely, and I think that's consistent with Tachi. For example, if ultimately there were a bunch of delays that occurred afterwards, similar, like inherently unknowable or defenses that were unknown at the time, like latent defects or defective work, which ultimately gets
Or
set off.
fraud that was hidden or something?
Yeah, absolutely. So that the mechanism for that, I think, is the counterclaim. I don't think you could assert it as an affirmative defense because there has to be some.
What would be the counterclaim if what you're saying is impossibility? What's the title of the claim?
Maybe it's a claim for declaratory relief. Maybe it's a claim for, breach of, it wouldn't be.
Why does it matter whether it's an affirmative defense or a counterclaim?
Because I don't know how you would independently try, because once judgment would enter on the Prompt Pay Act portion, there would be no claims available to raise the affirmative defense. There would be no mechanism.
There would be an affirmative defense, and then you would take evidence on the affirmative defense.
I guess that would happen. I don't know, and I guess it would happen after. So I guess procedurally, what would happen?
It would mechanically end up in the same place where there would be this determination by a judge as to, well, you were owed this because those were your bills, and then there's some portion of them that are, to which they had a valid impossibility defense, figure out the math on that and do the calculation.
Yeah, there would have to be some, yes, there would have to be some mechanism to raise it after you dealt separately with the Prompt Pay Act, giving the effect to the legislature and allowing that judgment to enter, and then allowing the owner or the person who is responsible an opportunity to set that judgment off.
Well, I don't know if judgment would need to enter first, but we'll look at Tachi to see. I don't know what would preclude the judge from determining whether or not there was the impossibility defense before entering judgment.
Well, my only suggestion, Your Honor, is it's really difficult to allow that sort of gap. I understand practically what you're saying.
You might get a liability judgment. It doesn't mean you'd necessarily get a damages judgment. You would get liability.
But I think that interferes with the legislative intent, which is basically say it or waive it. And I think that's significant here because
I don't see that. It seems to me the legislative intent is who gets to hold the money while this stuff gets figured out. And the legislature says that the subcontractor in this case gets to hold the money while this is litigated, but not that any defense action is waived, just where the money sits while you're discussing, while you're debating, while you're litigating it. But why is that wrong?
But I think part of the difficulty I'm having is when the defense is identified, and really it's a fact. What the value of the Prompt Pay Act is it's a fairly limited and fairly discrete obligations put on contractors either to reject it or approve it. Fairly simple. And what you're suggesting is adding a factual component to what's a fairly objective standard. is the defense knowable at the time? Why didn't you raise the defense in response to prompt payment? Are these types, and they are contractual defenses, what types of contractual defenses can you raise after the fact? You have a whole now set of criteria that you're applying to what was otherwise a fairly objective and discrete standard identified by the legislature and simply applied to pay applications. And that was the real difficulty I was struggling with when I saw the argument. And it's one of the reasons we thought the argument was without really basis in the language of the statute. It seems, at least superficially, to conflict with the legislative intent of raising the issue, especially here.
I don't know, because, I mean, to read the statute to say, I mean, in an absolute way, that if you didn't raise it in accordance with on the timeline of the Prompt Pay Act, all other defenses are waived that you might have to these charges, regardless of their legitimacy, I don't know that that would be a reasonable reading of the statute, at least in my view.
Well,
It's not a question of waiver, it's a question of timing, it seems to me.
Well,
Now, you may have an argument that it was waived because they didn't raise it properly in the litigation itself. At that point, it's clear they knew about the pandemic, they knew about the defense, and they don't raise it as an affirmative defense in their answer. That may be the end of the story.
I guess what I'm struggling with is the application of the prompt pay law and its remedial impact on subcontractors, because your suggestion that defenses could still linger to payment seems to be inconsistent with the intent and the plain language of the statute. Because when the language in the statute is mandatory. It says, if you approve an application for payment, it says shall pay. It doesn't say may pay, it says shall pay. And there's no other additional.
And then your argument is, in that case, the subcontractor is forever insulated from any claim for recoupment or defense to payment.
That's for that particular provision, but if there's independent damage that results as a result of the subcontractor's damage, the owner's not foreclosed or the general contractor's not foreclosed.
What about fraud? What if it's later discovered fraud?
But that's a good point, fraud, because then there is damage. That's an independent claim, could be asserted against a subcontractor, wouldn't be waived. But what I'm talking about here is a defense to the actual payment itself.
Right. Based on a defense, what do you mean by that? Defense to the actual payment itself?
I'm looking at the application for payment in isolation. And what the legislature intended, at least from my reading of the act, is that at that time, you either raise a defense to payment, you reject it.
If it's known or knowable, right? You would agree with that? Even you're waiving even the unknown claims? Is that your position?
I'm saying that's what the language indicates.
So do you think are you arguing that that's a reasonable interpretation of that language, that the legislature intended that language to result in a waiver of even unknowable claims?
When you say, this is sort of what I'm struggling with when you say claims. If you're talking about fraud, there's always an independent right to fraud. Just like in the Tachi case, there was independent damage that was allowed to offset, and the Prompt Pay Act doesn't impact that. What we're looking at in isolation, the applications for payment when they're submitted. And it seems to me at that time, you either have a defense to payment, in which case you reject it, or you waive it, because otherwise, deemed approved would have absolutely no impact.
No, it would mean you turn over the money.
Yeah,
and
if there's an independent claim, sorry, let me just, if I.
Go ahead.
Sorry, I didn't mean to interrupt.
Go ahead.
No, but if there's an independent claim to offset that, there's nothing in the Prompt Pay Act that precludes that. And in fact, that's absolutely consistent with the legislative intent.
Could you bring a counterclaim for rescission of the contract?
I guess you could bring a claim. There's nothing in the Prompt Pay Act that would prevent.
Based on impossibility?
Yes, you could bring a claim for it. I think there would be a lot of practical problems to that once it's performed, but yes. And I think that's a distinction which could actually be applied. It's consistent with the plain language. It effectuates the legislative intent. And you're not dealing with these issues of, is this a defense knowable or unknowable? The legislature absolutely did not want to have that subjective provision, because that prevents exactly what we tried to do here, an expeditious resolution of discrete payment claims. Otherwise, we're having fights over whether the defense was knowable or unknowable, which is inherently subjective, and we're having a trial, and a trial seems to defeat the legislative intent. If there's independent claims that are associated in damages which flow, like you said, from fraud, or from damage that occur, or from delays that may have occurred that weren't knowable at the time, or from latent defects.
Legislative intent is prompt payment. As long as prompt payment is made, nothing about litigation later to recoup violates the legislative intent.
I disagree with that because even the appeals court in Tachi identified litigation, ancillary litigation, as one of the remedial issues that the Prompt Pay Act was attempting to resolve. And your suggestion that this payment is somehow temporary, it seems to be inconsistent with the intent of avoiding the litigation and getting the subcontractor the money quickly. Otherwise, the prompt payment, I think, loses its remedial impact. And we're facing litigation. I mean, and I know my time is up, but the only thing I would suggest, Your Honors, is my client was owed $255,000 in approved applications for payment. There's absolutely no justification for us being here today. And we had asked for sanctions. And that's not insignificant in a case like this.
We understand. We have your argument. You made the argument in your brief, and I appreciate that. I'm going to just check to see if anyone has further questions for you. All right, thank you. We're going to have to leave it there. Thank you both. Thank you both for your able arguments and your briefs. And the case is submitted. We're going to take our morning recess, and we'll be back in 10 minutes.
All rise.
Welcome back. The next case is 2022 P0921, Virginia Musker versus JR Development. And is it Attorney Zaleskas?
That's it. Yes, Your
Right.
Honor.
Thank you very much, and we're ready whenever you are.
Thank you, Your Honor. Good morning, and may it please the Court, Kara Zaleskas on behalf of the abutter here, Virginia C. Musker. Understanding that you've all read the papers and have probably a more robust understanding of sort of the facts that make this case a little bit more interesting than the usual standing/land use case. I'm going to just sort of delve into the application of the law to the facts, and in particular try to address this issue that sort of kind of comes at the end of our brief, and it relates to this issue of the variance being unlawful on its face. And as we point out in our papers, the statutory power for permitting or variance authority stems from Chapter 40A, Section 10. And it basically lists off 6 separate requirements for such an agency or board to have that power to issue a variance. And it's obviously after a public hearing, after adequate notice has been given, where such, and this is sort of the important part, where such permit granting authority specifically finds that, and then here are the findings it has to make. Owing to the circumstances relating to soil conditions, shape or topography or substandard structures, and specifically affecting that land or structure, not just generally the neighborhood or region in the area, that the literal enforcement of the local laws would involve substantial hardship, and that desirable relief may be granted without substantial detriment to the public good. So here we have a case where the variance decision on...
Did you raise this argument down below?
Yes, it's in our initial summary judgment
And it
papers.
wasn't reached, right?
It was never reached.
Right, so why would we reach it in the first instance?
Because the argument that a butter can be divested of standing when a non-conforming lot is authorized to be further non-conforming by virtue of an invalid variance necessarily grants standing, or at least it's our position that it...
Maybe I wasn't clear. Let's assume we agreed with you on standing.
Yes.
How would we reach the argument about the validity or invalidity of the variance on the merits in the first instance here? Wouldn't that need to be determined down below first?
Well, this court does have the authority to look at the face of a variance and determine based on its whether it's valid or invalid, rather and basically short-circuiting.
Is your client's only challenge to the variance on its face?
Well, yes, she challenged the variance, she limited
So
it.
that's the only challenge she's raising on the merits is to the face of the variance.
That the variance, that the board of, the zoning board of appeals lacked the power to grant the variance, and therefore the variance itself is unlawful. It's a statutory argument. It basically says, and this is Massachusetts law in our actually summary judgment briefing, which is in volume 1, discusses how under Massachusetts law, these express findings that correlate with the statute have to be made in order for the
Okay, but the failure to make findings, I'm not having a hard time putting my finger on your argument. You just said, I believe, that the board lacked authority to grant the variance. Is that actually your argument, or is your argument that they didn't make the findings necessary to grant a variance?
Well, I think they go hand in hand, because the statute itself states that the power to grant the variance, which obviously stems from that statutory provision, only arises if the following findings have been made, the findings I recited earlier. The variance decision itself needs to contain those findings. And so I guess it may be a little bit confusing, but whether the board had the power or whether the variance on its face is invalid, the same result is warranted, which is that the variance should be stricken down and ruled invalid, and that the developer has to go back to the drawing board, essentially, and make those arguments that he experienced a substantial hardship, that these variances are necessary because of the topography, soil conditions. Like, these are the things.
Why wouldn't it just be for the board to make the findings?
The board, excuse me, I'm sorry, I couldn't.
Why wouldn't it just be if the only thing the board did wrong was failing to make findings, wouldn't it go back for the board to make the findings?
Right, but then I guess the corollary is, could the board actually make these findings? And in our papers, specifically the papers at the trial court level, which again, volume 1, the board couldn't make the findings of substantial hardship because there is no substantial hardship. The developer here purchased a property out of foreclosure, and from what I can tell, the variance is to split the lot into 2 lots, make 2 large structures, one 2-family, one single-family, and to maximize the value of that property. Well, that's not a substantial hardship. Being able to maximize your profit as a matter of Massachusetts law is not a substantial hardship. I mean, it would be certainly a different situation if they bought the property and all of a sudden there was an issue that required them to move the property, and if they didn't move the property, they would have, millions of dollars of remediation costs. So in that circumstance, yes, the board would be able to find that there's a substantial hardship, that the property should be moved, and it would be difficult for abutters to claim at least and challenge the variance on the basis of substantial hardship.
And that's an argument that was made below?
Yes, it was an argument. I apologize because obviously the volumes of the record are voluminous, but there was a summary judgment briefing. Mrs. Musker first served her summary judgment papers in April, and it was a sort of a summary judgment, then cross motion. But in the initial papers, there's a citation to case law that specifically finds that the desire to maximize financial benefit is not in and of itself a substantial hardship that would warrant the granting of a variance. And frankly, I'd hate to live in a state where the ability to maximize your profit is considered a substantial hardship. I mean, it's
Could you turn to the question of standing? Could you turn to the
Sure.
question of standing? So,
Absolutely.
On the flooding issue, the developer says they rebutted your client's presumption of standing based on the affidavit of their expert, as well as the Board of Health's comments that were submitted before the ZBA. So do you agree that that was sufficient to rebut the presumption?
No, it
Why
was
not?
not. First, the affidavit itself speaks to what the best measures after the project is completed, and it didn't address specifically the harm and injury that is occurring to the property currently as part of the
All right,
construction
well,
process.
this is where I'm a little puzzled. The photos that you offered and the affidavits speak to the conditions that occurred after the developer cleared the old structure and cleared some of the vegetation on the property, right?
Yes.
Okay. That was done before they appeared before the ZBA for the variance. So why is that relevant?
Because as part of the ZBA, well, it's relevant. May I first actually just address the initial question about the affidavit not being sufficient to rebut
Okay.
the presumption?
Well, I mean, you started out by saying it was because it didn't address.
It didn't, okay, I'm sorry. So yes, it did not address the fact that there's currently flooding occurring. And your position, and your argument, as I understand it, is that
Well, it's not an argument, it's a question.
I'm
It's
sorry.
the current conditions were caused by things that occurred before the hearing or the application on the variance. And I'm trying to ask, why is that relevant, and why does that mean that the affidavit is not sufficient?
because the affidavit speaks to there being no harm after the project is completed. It doesn't speak to the harm that is ongoing and is going to be ongoing for the near future.
What's the ongoing, where in the record do we see any ongoing harm?
I believe Ms. Musker's affidavit and then the pictures state that this is, the water issues have continued to be a problem.
But don't
both
you have to
from-
be aggrieved by the variance?
Excuse me? I'm sorry.
Don't you have to be aggrieved by the variance?
But that is the I mean, I think that is the agreement, is if a
Well, the
project.
flooding happened, all this stuff happens before the variance.
And during, and there would be an argument that obviously.
It's very hard to argue that something was caused by something that happened after it. If you're telling me the flooding is caused by the variance, but it existed before the variance, I'm going to have a hard time accepting that.
And I think part of the problem is that there were, as indicated in our papers, there were permits issued or actions taken without proper authority granted. So everything's essentially been a mitigation effort now. And I mean, I guess the problem from the abutter's perspective is that if a developer takes actions that necessarily predate the variance, but make the conditions such that a variance actually improves the situation, and that it will create an obligation to, to implement mitigation remedies and these things to improve the flooding or water runoff situations. If these actions predate the variance and then the variance is issued, then you divest every direct abutter of standing by doing it that way.
If the variance makes your client better off, then she's not aggrieved, right?
But there are obviously other reasons for Ms. Musker challenging the variance, and I think that the other one is the increased in density population from switching from one single family house to two structures and multi-family
Was the
house.
original structure not a three-family house?
So it's very unclear whether that was, I know Ms. Musker in her complaint listed it as a multi-family house.
In the ZBA, I think it was in the minutes of the hearing, it also refers to it as a three-family house.
And I think that it was, but, and for argument's sake, let's assume it was a three-family house.
So, I mean, in your brief, you say that it's going to increase the number of households, but if it was a three-family being replaced by a two-family and a single-family, then...
Well, it's going,
Right.
I don't, and I've never seen from the developer or the town any documents indicating that it was a legal three-family house. Now, that's obviously
But
a
if
major
it goes back to the 1800s, is grandfathered
Right,
in.
and
It couldn't have been zoning in
it's-
1800s.
It's a historical building that dates back, as you said, as you mentioned, way back to the 1800s. The issue obviously is whether over the years, prior to, I just don't have any, I don't know what the evidence is on this, when it became a three-family house. At what point somebody said, I'm going to make this multi-use, even though, and you know, I guess, you know, the town did not necessarily deem it necessary, it didn't deem it necessary to stop this non-conforming use, or, like I said, I don't know when the non-conforming use started. Nobody's made an argument as to that. And if it happened, if the non-conforming use started after the implementation of the current zoning regulations, it's not a use that the developer could even incorporate into his new project. It would still be a single-family rural residential district.
Assuming this increases the density, where's the evidence in the record that that harms your client?
Again, I'm relying on case law that there's a general right to private enjoyment that one experiences and is entitled to on their own property. And that right of quiet enjoyment is impaired when one house, again, relying mostly on case law cited in our brief, when it goes from one to multiple households or one structure to two structures, courts are fairly consistent on finding that that is sufficient to confer standing, that there is an agreement of that right of personal enjoyment and quiet enjoyment of your property.
Let me see if there are any further questions for you.
No, I'm upset.
No. Your time's expired, and we've got your brief. Thank you very much.
Thank you.
And we'll now hear from, is it Attorney Bobrowski?
Good morning, Your Honors. Mark Bobrowski for the private defendant in the instant matter. Tom Lane with me representing the Zoning Board of Appeals. This is a pretty simple case from our perspective, and we think that the trial judge got it exactly right. Ordinarily in a standing case, the plaintiff, who is a direct abutter, is a party in interest with a presumption of aggrievement. But that presumption can be made to recede, be rebutted, if the issue is contested. If you find that the evidence submitted by the experts who testified on behalf of the project, that is credible evidence sufficient for rebuttal of the presumption, burden shifts, and the plaintiff, or the appellant in this case, has the obligation to come forward with credible evidence. Credible evidence, as defined by the appeals court and the SJC for that matter, is both qualitative and quantitative. Qualitative in that it must be of the type of evidence that is normally sufficient for the court to make a finding, and quantitative in the sense that they've addressed each and every argument that they've raised for standing. In the instant matter, the appellants raised the following issues for standing. One was water, flooding, stormwater management. That's all one package. Another issue was risk of fire danger associated with the new construction of these buildings. The third issue was the other density-related concerns having to do more, I suspect, with privacy. And then lastly, there was an issue raised with regard to the value or the diminution alleged in the value.
I noticed you skipped over the third one. Population density.
Yeah, I mentioned density.
You mentioned it, but you didn't explain why that doesn't.
I was going to go back and do all of them in order.
I'm sorry. Go ahead.
So with regard to water, I think water is the type of issue when presented to a trial judge, and certainly there's case law to this effect, that it's beyond the ordinary understanding of the layperson. I don't doubt that they've shown pictures of puddles, but there's no cause and effect associated with that arrived at by testimony of an expert. Yes, this puddle was caused by.
Doesn't matter. We don't require as a bright line that it be presented by an expert.
I understand.
So we've got here an affidavit that says these water impacts, I mean, we have multiple affidavits actually, these water impacts occurred after your client started to tinker with the property, let's call it. And I'm not really sure why that wouldn't be enough to establish standing.
I don't understand the standing cases to hold to the proposition that the measuring stick is what's going on during the permitting. It's what's going to happen after the permitting.
This
And the
is for
cases are littered
standing.
with
This
that.
is for standing only,
Yes.
right? So unless the judge has a basis for determining that those impacts will not continue after the project is completed, I don't know how you get there.
You get there,
Right there, this was a motion, these were cross motions for summary judgment on the issue of standing. The record has to be taken in the light most favorable to the non-moving party, which in this case would be the plaintiff. How does the judge just get to credit that all the impacts will stop?
That's the nature of land use law.
Okay, but that's
Having
not the
had-
nature of summary judgment.
Well, but it is, in that when you move for summary judgment and you have an expert affidavit attached to it, whether it's projecting the future impacts of the project on traffic, on noise, on stormwater management.
And there's conflicting
that's credible
evidence.
evidence.
And there's
In rebuttal, a picture of a puddle is not credible evidence. That's an existing condition, perhaps. We have no cause and effect testimony as to why it happened, where it happened.
Okay, assume I disagree with you. Assume that I think the record, if you read the record in the light most favorable to the plaintiff, that the plaintiff has raised a triable issue of fact regarding her standing based on water impacts.
I don't think that
What then?
If they had done that, we'd be in a different situation.
Okay, I
We'd go
asked
to
you
trial at
to
that
assume,
point.
right, I
On
asked
the
you to
merits.
assume that the issue was not susceptible to disposition on summary judgment. I'm going to ask you to assume that. Then there would be a trial.
There will be a trial.
And you can, okay, so one of the problems I have with your client's position is this, I'll just call it assumption, but maybe I'm wrong and it's not an assumption, that the water impacts will be entirely mitigated by whatever was required. I don't actually see a requirement as to the mitigation, and I'm looking at the ZBA decision. I don't see a condition. I may be misunderstanding. I'm looking at Record Appendix 2, page 10, and maybe you can look at that so you can help me with it.
I know the answer. There's a stormwater management.
You don't know
permit
the
that was issued by
question
the
yet.
Board of Health.
You don't know the question yet.
Sorry, Your Honor.
Okay, but I'm going to be very impressed if you know the answer. I see on that page 3 variance conditions. I don't see that one of the conditions, and I may just be misunderstanding, is compliance or effectuation of any particular water mitigation plan. Am I missing something in those 3 variances? As 3 conditions, which condition is it that predicates the variance upon compliance with a particular plan for the water?
There's a separate stormwater management permit issued under a general bylaw by the Billerica Board of Health,
Okay.
subject to their regulations.
So I saw that. So
which-
I guess the answer to my question is that the variance itself was not conditioned, does not have a condition requiring compliance with that.
No, I believe that the Board of
Okay.
Health testified at the ZBA
Yeah.
public
And-
hearing.
And so then the other question I have, which is a question about just what the ZBA actually found. So I see also on that page that the ZBA wrote that the Board of Health, the stormwater management permit states that or maybe it's not the permit that states it, maybe it's a memo from the Board of Health. Doesn't make clear to me because it just says it also states the stormwater runoff to abutting properties will be reduced by 60%.
Yes.
What's the baseline date for that?
After the project is constructed,
From when?
when the
As measured,
certificate of occupancy
as
is
measured, no, what's the before? 60% of, from when, or from what? So
would-
is it 60% from after your client has increased stormwater runoff? Is it 60% from before your client, you know, is it 60% from when, as measured against the pre-existing condition of the property, let's say the day before your client bought it? Or is it 60% of some later date?
I believe it would be on the date Beta conducted its peer review and reported to the Board of Health.
Okay, so forget about belief. Where am I going to find the answer to that question in the record?
I don't think it's available in the record.
Okay, so to the extent that the judge was arguing or was relying on what would be mitigated, or to the extent your own argument depends on a finding of what and to what extent the stormwater would be mitigated, how does anyone get to that on summary judgment if it's not in the record as to what the baseline was?
Your Honor, I think that the process that unfolded in Billerica Town Hall was comprehensive and thorough in nature, including peer review by Beta, a reputable firm, under the stormwater management permit. At the end of that process, they issued the permit. They also transmitted a letter to the ZBA and said, good to go. And Mr. Noonan testified to that in his affidavit separately with his expertise, that it was good to go. That's the essence of a land use case. The traffic engineer says nobody is safe for pedestrians and motor vehicles. The noise consultant says it won't interfere with the Mass DEP noise policy, 10 dBA above ambient. It's all projection in these cases. It's what happens after the project is on board, is operational. It's not during the permitting process. No project would ever go forward if we were going to factor in construction noise. That's not what we're looking for here. We're looking for a projection in the operational stage. Will it be safe? Will it work under the criteria for the issuance of either a variance or a special permit? And the water projections here are no different than noise and traffic, which are everyday issues in land use cases.
What do we do about the argument that the ZBA did not make specific findings about hardship or topographical conditions?
Well, I think the answer is on the very last page of my brief. Since the Murata case, which is pretty old at this point, it's been a bright line in the case law that if the plaintiff does not have standing, then there's no need for the court to reach the merits.
Okay, assume for the moment that we were to determine that she has standing. What should we do with that argument?
Again, as I said, if she has standing, then we go to trial.
Then you go to trial on all of those.
And standing can be raised at any point in the proceedings, so be sure that it'll be raised again at trial.
Oh, no, of course. There may even be a bifurcated procedure by which standing is tried first.
And they're done that.
Yep.
So let me ask you about population density, because the Bertrand and Murray cases both seem to have a pretty low standard for what you have to show for agreement on population density.
I don't think that that's the case. If you look at Murchison, which is cited in my brief, but I wanted to make sure that the court found this language within the case on page 214 of the SJC version. The court says, to establish standing requires a plaintiff to do more than merely allege a zoning violation. The language of the bylaw cannot in itself be sufficient to confer standing. The creation of a protected interest cannot be conflated with additional individualized requirements that require standing. The injury must be causally related to a zoning violation, and it must be more than de minimis. And then after that, in the next paragraph on page 215, the court says, these are factors to consider. There was no evidence, for example, that the defendant's project was shut off of view, and it cites 81 Spooner Road. Material affect the plaintiff's privacy in relation to their home, and it cites Dwyer, as did the appellant, or significantly reduce lighter air. The density here is compellingly in favor of the developer. The distance between the corner of the proposed closest building to the property line is just under 200 feet. It's 199 feet. And the distance from the corner of a new building to the corner of the MUSKER home is 310 feet. Dwyer is not a case which was heavily relied upon by the appellant like that. Dwyer was a case in which there was a 12-foot and a 15-foot transgression in the side and the rear yard property lines. The court just last half of the year decided on appeal Quozo, which was a case in which there was a shed placed 15 inches, I believe, from the property line. And yeah, that was a density problem. Nor was there any evidence introduced in this case, as the court noted in Murchison, where there was a pattern of density well in excess of what was allowed under the zoning bylaw. So I don't think any of those density factors line up with the other cases that have recently been decided on the issue.
Could I go back to the water issue? Can an abutter appeal from a granting of a stormwater management permit? Did the abutter have any right to challenge
Sure.
the stormwater management permit?
I believe that there's an appeal provision within the bylaw itself. If not, they always have certiorari.
Okay, what about the building permit?
The building permit has a 30-day appeal period to the building inspector to revoke first, and if that deadline is missed and it's something that they did not know or could not have known about the issuance of the permit, they have a 6-year
How do the
statute.
abutters get notice of the building permit?
In some towns, the town actually provides notice of new construction. Wellesley is an example. That's the Gallivan case. Otherwise, they just have to go to the barricades and inquire on a regular basis. If they miss the deadline and they did not have a duty of inquiry, they do get the zoning enforcement route, which is a 6-year statute of limitations. So it's appeal within 30 days if you know about it, or take your alternative remedy, but you'd have to show you didn't know about it. And that's the 6-year period of zoning relief afforded by Chapter 48, Section 7.
Permit's got to be displayed on the...
I'm sorry, sir?
Permit's got to be displayed on site, right?
Yes. And there's cases in which the abutter did not get notice, like in Wellesley, but Connors, for example, is something in which they got late notice, but it was still within the 30-day appeal period, and they waited until after the appeal period expired by 10 days or 2 weeks, and then appealed, and the court said, sorry, you're too late. Here, I think the matter doesn't turn so much on the building permit
I think
as it does on the
you are
variance.
out of time, so we're going to have to leave it there unless there are further questions.
I appreciate that. Thank you.
Let me check to see if there are any other questions. No. Okay.
Thank
We have
you.
your brief. Thank you very much, and the case is submitted. Thank you both for your arguments. We're going to wait for there we go. Okay. The next case is 2022 P0883, Webster Bank National Association versus David FARRAG, I'm not sure how to say it, and Attorney Hughes.
Yes, Your Honor.
Okay, we are ready whenever you are. Please just remember to adjust the microphone and to speak up.
I will. Thank you, Your Honor. Good morning, members of the panel. May it please the court, my name is Brian Hughes and I represent Webster Bank National Association. The defendants in this case demanded that Webster Bank mitigate its damages and establish its loss before prosecuting it beyond the initial pleading stage. Webster Bank acquiesced to that demand and began engaging in that work, which took many years, as the record shows.
Where is that demand in the record?
It's it was in the culmination with the joint motion to stay. They requested mitigation, and Webster acquiesced, so we
The
drafted.
motion to stay says stay until foreclosure.
Yes,
Okay.
yes.
That's your-
Basically, the mitigation of damages would have included foreclosure and taken possession of
Well,
property.
now, why and taking?
Because Webster's damages will increase if it had to get into a fight over to evict. That's still racking up the damages that were caused by Mr. Raji's intransigence, which was caused by the defendant's Webster's allegations of fraud and mishandling of the loan closing. It's all part of the same puzzle, the same ball of wax.
The damages aren't determined by what it sells for at the foreclosure sale?
No, Your Honor, first off, Webster bought it back at foreclosure, but
That's your decision to
yeah.
do it. It's not
It,
the plaintiff's.
a credit bid, and the amount of that credit bid is taken off the top. And that's what Webster would be alleging if it was allowed to proceed the trial. The amount, I believe, was $64,000, which was credited. But in order to get that, many, many years of litigation and expense and legal proceedings through, frankly, every court in this Commonwealth and the federal courts that's what it took to get here.
Yeah, but you got the $364,000 credit at the time of foreclosure. You didn't need possession to get there.
Excuse me?
You didn't need possession to get that number.
Possession actually occurred later, but yes.
I know it did, but
I can't hear.
why does possession matter? You're telling me the mitigation is the $364,000. You had that at the time of foreclosure. So what happens at possession that changes anything?
If possession wasn't an issue, it would have ended there. But it took 2 years or several years to obtain possession, and Webster's costs in doing so are still directly related to the initial claims in this case.
So what you're saying is they're all part of the damages that could be recovered on the malpractice claim?
Absolutely, Your Honor, because if the malpractice didn't happen, none of this would have
So
happened.
let me ask you this about mitigation. Normally mitigation reduces the damages, but at the time the lawsuit was filed, the damages were about $320,000, and by July 2018, it's $400,000. So your mitigation seems to have increased the damages. So how's that mitigation?
Well, the results of the mitigation were not as successful as anticipated because it took so long to get there. But the argument of the defendants is that Webster Bank had to exhaust its remedies and go through the process, and whatever the bottom line is, the bottom line is. Webster, in theory, could have walked out of there profiting, and then the mitigation would have been complete, and then would be no damages, and the case would have to be dismissed. The defendants, frankly, rolled the dice on that, and it came out slightly in the wrong direction. And I would suggest that's also a defense they can raise if the case proceeds to trial. That mitigation was
all the defendant said was that it shouldn't go forward until foreclosure happened.
Yes.
That's the only thing they said. Do you have any evidence they said they wanted to wait till you got possession?
Yes, but at the time, it was also that statement of foreclosure was also tied to the idea of completing mitigation. I believe that, the parties at the time didn't expect, it also says it expected 8 months, I believe, to complete the process, and it took years. This is an unprecedented kind of situation between parties in this case. We have a third party who is frankly abusing the system, even to this day. I have a hearing next month with Mr. Raji still. He's still fighting this. And all of that, it didn't come to a complete head until June 30th of 2021 when the keys were handed over to Webster Bank.
All right, so I'll try one more time. Is there any evidence, can you give me anything in the record that says that the defendants wanted you to wait until possession? They definitely wanted you to wait until foreclosure, I see that. Where's the evidence that they demanded you wait until you had possession?
Where possession does not arise. I concede that, Your Honor. But in the context of the motion and the documents as a whole, it all comes down to Webster establishing its loss. And its loss wasn't established until possession. And I would suggest, Your Honor, that if the defendants raised that, it would have been waived because I submitted to the defendants, after foreclosure. This is where we are right now.
Let me ask you this. If that's true, how could you send a letter in July 2018 with a demand for your loss if the loss couldn't even be figured out until 2021?
Because, Your Honor, the foreclosure had been completed, and at this point, we're looking to settle the case. That's a settlement demand. Frankly, if it wasn't for the fact that it refers to our, informal agreement to stay the case, I would have objected at the Superior Court because it's inadmissible. Your Honor, if the case could have settled then,
All right,
Webster Bank would have walked away.
where you wrote, this is you.
Yes.
As agreed, now that Webster has foreclosed, its loss can be established, in this case either settled or litigated. You believe that the judge below had to disbelieve that, disregard your words? What's the theory here?
It's well, first, if it has to be taken in the context of settlement, whether or not Webster Bank would have incurred more damages at that point, if the parties settled, Webster would have just taken the loss. But the parties didn't settle. My overtures were ignored. And since Webster had to keep going in the process to finally get possession and dispose of the property, then the defendants, I would say, ignoring of that letter or acquiescence essentially caused a greater loss. And at some point, they do have an obligation to stand up for themselves as opposed to saying absolutely nothing and letting Webster proceed with the process. And they haven't argued that Webster's loss ended there.
Do you agree? I understand your argument that dismissal was an extreme sanction or remedy in these circumstances. Do you agree that the judge could have, for example, told the period by which you would be entitled, during which you would be entitled to prejudgment interest?
Yes, I believe that's in Chapter 231.
Right. And it might have been reasonable, I take it, for the judge to have done that for the period after the date of foreclosure, or perhaps even when you sent your settlement letter through to the date of the motion. Is that?
Yes, the court would have had the opportunity to have an evidentiary hearing and make a ruling in that vein, yes. So, Your Honor, and one of the issues in this case is that the court found prejudice, but there really was no evidence of prejudice. There's no affidavits. There was nothing factually in support of prejudice other than the passage of time, which the case law
which
supports.
they identify as being translating into money, and that's why I asked you about
Yes.
the tolling of interest, accrual of interest. Yeah.
Yeah, the interest is a stand-in for essentially the time value of money.
Passage, right.
And, you know, the case law does say that the mere passage of time is not sufficient if the plaintiff comes forward with a reasonable excuse. Obviously, our case is that Webster had a reasonable excuse and that the Superior Court disregarded it and just looked to the four corners of its own docket. And because of that, I would suggest that's not taken into consideration the totality of the circumstances and whether or not Webster acted reasonably, and that is reversible error, Your Honor.
I mean, as early as 2016, I think that's when the appeal had concluded, right, of the third party.
The latest, yes.
Mr. Rudd, yeah. You sent an email to the other party were acknowledging that the stay had expired, right? And that it was time to start litigating the case. So what justifies a further delay from that date to 2021?
Well, because in those emails, I believe we're talking volume 2, page 227, 229.
Yeah.
You know, there's reference in there to our agreement, not on the record, but I refer to it as an informal stay in those words, because we had an agreement that we weren't going to prosecute the case until everything was finished. At that point, you know, counsel didn't agree to litigate, and Webster Bank continued with this process, Your Honor.
Right, but, I mean, as you say, the 2016 email, it is time for us to litigate the legal malpractice claim, right? And then I take it you got no response.
None whatsoever.
So why didn't, at that point, did you not move the case forward?
Because, frankly, Your Honor, you know, the status quo prevailed up to that point. You know, if counsel didn't feel strongly that we had to prosecute the case and Webster Bank still had lots of work to do to regain possession of the property, it kept doing so.
Well, they're not prosecuting the case. You're prosecuting the case, right? I mean, I don't know why they had to do anything, really.
Well, if a party doesn't raise unreasonable delay in a timely manner, that is actually used against them under the standard.
That seems a little contradictory, right? I mean, they don't have to do anything. It's your case, right?
Yes, but at the same time, since we had this informal arrangement going forward all these years, it just continued.
Can I ask you another question about the 2016 email? Because above it, it says, hi, Brian, I left a message with you yesterday. Please give me a call back when you get a chance. So what happened with that? You said there was no response, but that's a response. What happened when you called them back?
Frankly, Your Honor, I don't recall the conversation. I just don't.
So it's possible you he said, call me, and you didn't call him?
It's possible in the sense that I don't recall calling. I know I can tell you there was no substantive conversation about the merits of the case moving forward with litigation or settlement. Yeah, I have to admit, the absence of a memory, I don't know if there's a call. Maybe I called back and left a voicemail and things trailed off like they tend to do. So, Your Honors, the court below, under Rule 41, there must be convincing evidence of unreasonable delay. Not some evidence. That's found in the Monahan case. It has to be convincing. And I would suggest, Your Honor, under the reading of this record, that the evidence is not convincing that Webster acted unreasonably. When we talk about the 2016 emails, that was before 4 other lawsuits were filed and prosecuted against Webster Bank by Mr. Raggi and his counsel in this case. A lot of water went under the bridge after that email. So I would suggest that since Webster had to keep defending these actions because of the defendant's actions back when they closed the loan, that was tantamount to having to further mitigate, having to further put work into it and determine the loss. And then at the end of that is when Webster Bank immediately notified counsel, said, we got to settle this, or we have to set up a Rule 16 conference. That went
You don't think it's unreasonable once the stay expired in 2014 to not file anything with the court for 7 years?
Considering the conduct of the parties in this case, Your Honor, I would say it wouldn't be patently unreasonable, especially since Webster came forth with some excuse. I mean, it's not as if Webster, like, we have a lot of these cases that like Buccieri, et cetera, where they did nothing. If you only look at this docket, yeah, it looks like Webster did nothing, but Webster did many things. It just didn't reflect on this
Isn't there an
docket.
obligation to inform the court and file something in court in the 7 years that passed since the stay expired?
The rules don't require status reports, and sometimes these days, actually, the courts tend to send out notices for status reports, but generally
Was
it's
there not
solicited.
some sort of scheduling order in effect at the time?
Not one that was
Wasn't there
in
one that
effect.
was then extended, the tracking order was extended?
Yes.
And all those dates passed, right? So there's no obligation at that point to file something for a continued stay or to further amend the tracking order?
There's nothing in the rules or in practice in Plymouth County that calls for that. I mean, frankly, Your Honor, I'd be shocked if any cases.
Can't you be dismissed for not filing, meeting the deadlines in the tracking order?
If the court ordered the show cause, I would have to defend the matter, but I believe cause would have been shown here considering the circumstances. I believe that would be the procedure that the court would take. And now I don't know if it's because of a change in the standing order, but there are procedures in place now to have courts keep track of cases. But we can't judge 2010 on the 2023 standards, Your Honor. And still, considering the course of the parties, I would suggest that should be more appropriate of a standard to apply or to look to than just what does a docket show, because there's so much else that went on besides what was before Justice Glennie, and I'd ask that the court reverse the decision and remand it for further proceedings. Thank you, Your Honor.
Thank you.
No, if there are any further
Let me
questions.
see if there are any questions.
Thank you.
Is it Attorney Blazajewski? I probably got some part of that wrong. I'm sorry.
Pronunciation was perfect. Thank you, Your Honor. May it please the court, Chris Blazajewski of Sharon and Lodgen on behalf of Mark E. Robinson and David H. Farrag, defendants and appellees in this matter. I just really want to raise 3 points. First, this court should follow the Supreme Court's decision in Bashir and affirm the Superior Court's well-reasoned decision under the rule. Second, that the court should affirm the Superior Court's decision where the Superior Court properly found that the Robinson parties had been prejudiced by Webster Bank's delay. And third, that Webster Bank's entire argument here on appeal is undermined by its own admission to the Superior Court that the stay in this action expired, and expired long ago. First, Rule 41b2 states, and I think we all know this, that on the motion of defendant which occurred here with notice, which also occurred here, the court may, in its discretion, dismiss any action for failure of a plaintiff to prosecute. Now, the appeals court here reviews such decisions under abuse of discretion standard. And Bashir, the Supreme Judicial Court reversed the appeals court and affirm the trial court's decision to dismiss the action there for failure to prosecute. And I think there's language that's really important to focus on in the Bashir decision as to the standard of review. Court there says, the allowance or denial of a motion to dismiss for failure to prosecute is committed to the judge's sound discretion. As with most rulings by a judge regarding the management of a case, only in rare instances can it be ruled that there has been an abuse of discretion amounting to an error of law. Abuse of discretion, and we all know the standard: arbitrary determination, capricious disposition, whimsical thinking, idiosyncratic choice. There is no error of law amounting to an abuse of discretion simply because a reviewing court might have reached a different result. The standard of review is not substituted judgment. And, Your Honor, panel, Bashir is controlling here because the time periods of inactivity in this action are multiple times longer than the time period.
That's the problem, because the judge here treats it as 7 years. But you agreed in a filing that was in front of the judge that nothing should happen until foreclosure. And it's only 3 years from foreclosure. Now, that's a lot of time, too. But the judge is treating this like a 7-year thing, not a 3-year thing.
Your Honor, I don't think that's the case, and I don't think that's in the record at all. The motion you're describing is a motion to stay pending foreclosure that was filed in 2009.
All right.
That motion was allowed.
The moving parties agree, and your name is signed. I don't think you signed it personally, but I think with authorization. The moving parties agree that in order to fully determine the amount of damages claimed by the plaintiff must take actions to mitigate its loss by means of foreclosing on Mr. Raggi's property, and that said mitigation inures to the benefit of all the moving parties.
Your Honor, so that's a motion, again, that was filed in 2009, which created a stay that that concluded on September 15th, 2010. In the subsequent effort...
But it reflects what the parties agreed to. Do you see what I'm saying? It reflects what the parties' intended agreement was.
I don't think that's right, Your Honor.
Well, then there might be a serious problem with, I mean, how do we get, you both signed something you filed with the court.
Mm-hmm.
We're going to presumably take it as true.
Your Honor.
Don't you want us to take it as true?
Yes.
Okay.
As of 2009.
So take it as true that the parties intended to stay the litigation through foreclosure.
As of 2009. Then the court allowed the motion through, and it expired on September 15th, 2010.
And then it got extended?
No, it expired on September 15th, 2010. The first stay pending foreclosure expired on September 15th, 2010. Subsequently, after the court entered judgment on the effort by Mr. Raji to vacate, a second request to stay was submitted to the court, which makes zero reference to an effort to foreclose. The only reference in that motion is to a stay pending appeal. There's no reference to foreclosure there. And so that is the evidence of the party's intent as of 2013. A stay, actually my mistake, Your Honor, 2011. That stay expired in 2014 when the court was reported back to the Superior Court that the appeals had been issued and that as judgment was supported. There's no reference in that 2011 motion to foreclosure. So yes, in 2009 there's a reference to an agreement, but there's no reference to that in the 2011 filing as to the joint motion to stay pending appeal. That stay expired in 2014. Now, Your Honor, on the record before the Superior Court, Webster Bank admitted that that the stay expired, that it sat on its hands, and it did nothing. And that stay expired in 2014. There's an argument by my brother that it was actually 2016 because an effort to go to the United States Supreme Court. Either way, we're not talking about a period of 3 years. We're talking about a period of 7 years or 5 years if you count the Supreme Court's argument. So I completely disagree that
Okay, so let's assume that the parties had come into court when you say they should have and asked for what the plaintiff actually did do at some later point, which is ask for status conference or some other conference to get the case moving, okay? Let's assume that. And at that point, they still hadn't evicted or managed to get possession of the property, correct?
Correct.
Right. No possession of the property. So moving forward would have left some component of damages yet undeveloped, right? There still would be out there because if your clients were liable on the malpractice claim, a component of damages would be whatever consequence their, damages were caused by their alleged negligence, which would arguably include the costs of obtaining possession of this property, correct?
Your Honor, I would disagree that that would be damages. But again, that's not an issue before the court.
It's not, except that it is a little bit, because let's say that it arguably is. You could have that argument. And so how would the case move forward at that point if damages are still in the process of being accrued? Assume that damages are still being accrued. How would the case move forward? You had issued or sent out discovery requests way back when. You never moved to compel. There was no effort to move forward on the discovery. Damages were arguably still moving forward. What harm is there in not going forward with the case at that point, as opposed to later when damages have been fully fixed in time?
Well, Your Honor, there's a lot of assumptions to make there. I disagree with a lot of them. But what I would point back to is the court's decision in Bashir. In that decision, the court...
I'm not talking about that decision. I'm talking about the facts here.
Okay.
Because the only harm I can see, to be frank, is the accrual of prejudgment interest. I don't see anything to support in the record an articulation of any other kind of harm.
But that's not the requirement under Bashir, Your Honor.
I'm just asking right now about the record.
So-
I didn't see anything other than the accrual of prejudgment interest, which I acknowledge at 12% is a significant chunk of change, and especially over a long period of time. But to my mind, at least, that could be remedied with a response short of dismissal, and the judge has an obligation to consider lesser remedies before the ultimate sanction of dismissal. I have a hard time seeing in my mind that the judge did that, because I don't see any consideration of that. I didn't see anything in the hearing transcript that would indicate any consideration of that. I didn't see that it's your motion. You have the burden on the motion. I didn't see anything that you put forward to establish any damages beyond the accrual of interest. And so I'm wondering how the judge goes from considering a sanction that looks like it would have addressed the prejudice that you did put forward to going to, dismissal of the claim in its entirety.
May I respond, Your Honor?
Of course.
So there is additional harm, and it is in the record. It's on the record below, and it's in the decision. So in the record below, there is evidence, and it's undisputed, that Robinson parties issued document requests, interrogatories, and requests to admit in 2009 that went unanswered. So
That you did not move to compel. That's
No
also, actually there is under the rules. So under the rules, you do have an obligation to move to compel. It wasn't done.
in Bashir, Your Honor, there's no reference to there being a requirement to move to compel.
Okay, but you just told me about the rules and what the rules require. The rules actually do require that you file a motion to compel.
So, Your Honor, my mistake, I used the word rules, I meant the law under Bashir. In that case, there's no reference from the SJC to any requirement that you move to compel. In that case, it's exactly the same situation. Discovery was issued, there was no response, and there's no reference in that just decision from the SJC as to any obligation on a defendant in those circumstances to move to compel
Okay,
in
so
order
I don't want to
trigger
get
the
us,
relief
I
under
understand what you're
the
saying.
rule.
I don't want us to get sidetracked. You told me that there's evidence in the record of prejudice beyond the passage of time resulting in the accrual of interest. And one you said is there's no response to our discovery requests. What else?
Additionally, Your Honor, there's an admission on the record that there were facts known to Webster Bank in 2009 that were not responded to.
I didn't see that. I saw that you said it in your brief, but I didn't see that the record said that. So can you please point me to the page in the
Yes, Your Honor.
record? What you pointed to was a passage in the hearing in which, referring to some statements that counsel for Webster Bank made.
Yes,
I
Your
didn't really see them as admissions. I guess that's open for us to interpretation as to whether they admitted that the passage of time had destroyed access to, what I read was that it said there wouldn't have been people even then.
Your Honor, so yes, and I'm referring to a Record Appendix 2, 267 from 18 to 21.
Let
In-
me get there,
Yep.
if you don't mind.
So RA 2, 267, 18 to 21.
Right, so what it said is, even back in 2009, there was no human being at Webster Bank that would have been able to testify to this even then.
And so that is harm because Robinson parties didn't know that fact. This is a case that was filed under a verified complaint where the allegations were verified by a Webster Bank employee. Now we have an admission from Webster Bank that in 2009 there was no one that could testify as to the facts in this case. To me, if we had known that in 2009 and gotten a response, we could have done something about that. That to me is a key.
Done what?
Could have litigated the case at that time under a theory that there are zero facts that support the claims against my client.
I didn't see that this was referring to what was alleged in the verified complaint. You'll have to show me that. I don't see that in this passage.
Well, the passage states that no human beings at Webster Bank were able to testify as to the matters raised at that time.
The judge's question before that to the lawyer, and we can read this. I don't need to take up your time. Go ahead, Judge Ditkoff. You had a question.
No.
Oh.
I'm reading this too.
The judge's question was, the question I've got is, the point they bring up all these witnesses or potential witnesses that worked at Webster and now perhaps have retired or moved on or even died over a 12-year period, aren't they prejudiced by not being able to access those? Where if you had answered the discovery, mentioned a witness that's no longer there, they could have at least, in theory, depose them and that testimony would have been preserved, and now that can't be done. Doesn't that prejudice them? That's looking at the prejudice the judge understood to flow from the lack of response to your discovery requests. I didn't see anything in there to suggest it comes from allegations in the complaint.
No, yes, Your Honor, it is. But I think it's why that fact is relevant is that there is a verified complaint where there's alleged statements under oath as to the material that's in the verified complaint.
Which is presumably based on the business records.
What's that?
Which I'm sure is based on the business records, which will exist just as well in 2023 as they did in 2009, which is what your friend says.
That's right, Your Honor, and that's where the timely discovery of that information is why we issued this discovery in 2009.
But then you didn't pursue it.
We did not file a motion to compel. That's correct, Your Honor.
Right, so if you had learned that this bank mortgage case was based on business records back in 2009, you would have done what? You would have gone to trial immediately? Was that the claim?
Well, Your Honor, I don't know what we would have done, but we would have had this information as opposed to obtaining it 12 or 13 years after the request for the information was obtained. And I think so if you look at the decision, Your Honor, the court says, in addition to the 7-year period, it also talks about the interest. And I wanted to highlight one thing. If you look at the Bashir decision, it also references a federal district court case out of the Ninth Circuit that itself says that the period of time is itself the harm to a party. So I think both we have the period of time, the lack of discovery.
Okay, we're going to have to leave it there, 'cause we have your argument. Let me see if there are any further questions. No. All right. Thank you both
Thank you,
for
Your Honor.
your argument and for your briefs. The case is submitted. That concludes our sitting for today, and the court is in recess.
All rise. We'll stand in recess. Guys, God bless you both. Enjoy the day. I gotta go get this suit off. What you guys think?